che sto su inglese a un certo punto.
Senti qualcosa?
Sto sentendo però a diretta.
Perché c'è quello come cuffia pure. C'è l'audio di questo e l'audio di questo, quindi. Sentite la voce?
Se non sto sentendo la diretta, non
Sta
so.
in diretta, non vediamo più parlare. Che senti così? Vabbè.
Non so cosa faccio questo. Sera qui.
Due audio sentiamo. Test, test, test. 20 secondi. Allora tu, levate questo. E basta.
Cosa mettete se fa a un certo punto stavo.
E questo è sfasato di 20 secondi. Non va. Ti regalo.
Cambio di immagine. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Provo un attimino a prendermi lo streaming. 1, 2, 3, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Cambio microfono, vado da quest'altra parte. Sul telefono io vedo a diretta. Perfetto. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Mi sposto adesso su quest'altro. Ho la chat aperta. Ok. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Buongiorno, prova streaming. Prova streaming, l'audio in sala si sente bene, questo lo rimetto così, questo lo devo direzionare in pratica, ok. Sto venendo.
Test 1, 2, 3, prova, test Università Mercatorum dal canale inglese, cabina inglese, test Mercatorum, questo è il canale per YouTube inglese, inglese.
3. Mi può anche parlare? Parlami. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Sto sul canale inglese. 1, 2, 3. Sto in ascolto sul canale inglese. 1, 2, 3, 1, 2, 3. 1, 2, 3. Prova. Prova audio.
Eccola, mi senti? Aspetta, mi metto la cuffia. Ok, yes, questo è il canale 1, prova di simultaneo, mi senti? Vado sul 2.
Ok. Sul 2, questa è la lingua inglese diretta dalla sala Mercatorum. Ok, ok, io non parlo, parli solo tu.
Secondo pannello, fammi un segno. Ok, questo è l'inglese. Terzo pannello, canale inglese. Sì.
È vicino Emanuele? Oh, vabbè, o devo venire a cercarla, cioè.
Che compaiono quelle dell'utente, questo qui, 5909.
Ah, mo. Cioè, in teoria già sta qua per le 9, però stanno trovando traffico sulla Aurelia che li porta qua, quindi tutta la strada del centro. In totale, come chiedi gli stranieri, è un convegno che ci sono 32 giudici dell'Unione Europea, di cui 4 o 5 sono italiani, quindi fate un conto di chi viene dalla Romania, chi viene dall'Albania, chi viene dalla Lituania, chi viene dalla Grecia. No, no, su 32. Poi ci stanno tutti quei pezzi. Eh? Sì, ma sistemi da adesso? Sai cos'è? Che adesso arrivano. Adesso arrivano e si mettono tutti qua dentro. Vuoi magari iniziare tra po'? Quando stanno tutti qua dentro, così. Grazie. Sì, assolutamente, è tutto tuo. E quindi poi tutti loro che vedi e poi altri relatori. Qualcuno invitato a presenziare così a sentire tipo convegno. Una cinquantina di persone, ma non ci arrivano a 50, 50, fai 50, non so 50. Non è arrivato nessuno?
Ci stanno tipo 3 persone.
Quelli sono gli interpreti?
Interpreti.
Sì, li vado a prendere.
Che facciamo posizione là?
E gli interpreti stanno dentro la stanza. Sì, posizionati da un lato dovrebbero iniziare a arrivare. Questo va meglio di quello, chiaramente, questo
Per
computer. Questo
quello
è
ci ho messo
nuovo.
questo, sì. Sì, è uno dei 3 che usiamo di solito. Stanno sotto chiave della questi. Ah, ci sta pure.
Hai capito tutta cose, guaio!
Non manca mai
Non coglioni sempre in prima linea, è il primo sempre, non ti sbagli. Avanti, come al solito è stata preziosissima. Roba realmente accaduta, fatti realmente accaduti.
Sì,
Ogni weekend mi scrive. Tu fammi pubblicherò? Sì, sì, puntualmente lui il sabato e la domenica ti scrive dicendo mettiamolo su social, baci. Sì, prof, ho risposto tutte le volte.
e poi lui, dove sto, è il vicepresidente della Corte dei Conti, una cosa del genere.
Sì, c'è un
E
ruolo
quando siamo
grosso.
andati alla Corte dei Conti con Federico non c'era nessuno. Cioè, siamo andati lì in segreteria, dobbiamo consegnare il pacco per firmare. Chi? Cioè, gli hanno detto, ma non sapevo chi questo firmano. Hanno fatti molto una telefonate per capire chi fosse, cavolo, il vicepresidente.
No, ognuno di loro viene con la penna USB, io c'ho solo quella che mi mano.
12,37.
No.
Audio 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Arriva l'audio a voi in cabina 1, 2, 3, 4, 5, 6. Non sento nessuno sulla traduzione, nessun canale impegnato.
Inglese, 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 inglese mi senti? Inglese mi senti?
Ecco, sento qualcosa. 1, 2, 3, 4, 5, 6, 7, 8, 9. Eccomi, ti sento, ti sento. Perfetto, questo è francese, esattamente. Francese.
Inglese, perfetto, io pure ti sento benissimo, solo che ho visto che l'audio è al massimo, non me lo riuscite a aumentare un po', di modo che se qualcuno parla basso...
Parla pianissimo, però il volume lo posso alzare, lui Paolo parla piano.
C'è un eco
Sì,
nella sala.
L'impianto è loro, però poi posso dare più volume io sicuramente.
sì.
Leggermente però.
Io.
Sì.
Ne do più io.
Guarda che c'hai il physique du role, sembra che non hai fatto altro in vita
Perché
tua.
abbiamo paura di quelli che parlano lontano dal microfono.
Esatto. Ok, va bene. Ok, basta che passi subito alle sanzioni in caso di... alle misure correttive.
è la solidità per insomma, che come fare per cominciare, insomma, io ho un po' di vista. Prego, prego.
Possiamo anche passare un po' di tempo, se no questi mi chiedono...
Allora,
È un po' di tempo, si dice.
Sì, allora, perfetto, passiamo le tende.
No, dicevamo, l'unica poltrona che dà fastidio che ci impalla lui è quella,
questo qui in traiettoria che però
solo quella.
non viene inquadrato.
Se mi spostasse leggermente.
No, no, se lei è proprio...
Questo qua, diciamo. Un po' meglio?
Sì, sicuramente così è meglio, sì, sì.
Era solo che volevamo schiacciarle verso il muro.
Lo so, noi non abbiamo fatto niente. Lei non ha fatto
Io non ho
niente.
fatto niente, quindi... Sì, magari la tenda, almeno di... Oddio, loro non erano previsti.
Anche di qui?
Sì,
Guarda, se vuoi, sì, è meglio.
facciamo simmetrica.
Sì, meglio, sì.
Lo operai? Va meglio così sicuramente. Vabbè, poi tanto non è che c'è registrazione. Solo di
Carissima. Carissima, hai preso tutto benissimo. Sono contentissimo. No, stiamo benissimo, stiamo benissimo, da sicuro. Poi la colazione oggi è stata buona.
Vabbè, perché quelli sono gli standard internazionali, tutto
Bravo,
uguale,
bravo,
capito?
bravo.
Tutto...
Agrigento perché c'era la commemorazione di...
Grazie. Questa è una cosa importante, cosa sì. Bianchi c'è? Ma mi chiede, volete parlare in inglese? Ok. Well, good morning to all people. Ladies and gentlemen, as rector of this university, I'm very pleased to welcome you here at Palazzo Costaguti. That is the seal of Università Mercatorum. And it is a pleasure to welcome you to this ECLJ. I think that they can hear. Thank you. At this ECLJ Summer School European Competition Law for the National Judges. I know that you come from many countries of Europe, and it's very interesting. I think that in the evening we can share some word because I will be with you at the visit to Cappella Sistina. So we have decided to give you this little gift for welcoming your stay in Rome and compensate all the problems that you can that you have just appreciated with the traffic of this town. The summer school has been organized in cooperation with the Pegaso University, here represented by Rector Bianchi. Only a few words about this university. This university is, as the name of Università Mercatorum, that recalls the origins and the nature of the Chamber of Commerce that are representative bodies working in Italy and representing the firms and their entrepreneurs. This university has an institutional mission to give skills to young, but not only to young people, also to people that work already in different fields in the economic activity, supporting the culture of enterprise that you know is very appreciated in the European Union. This university has been founded in 2006, so we can say that it is a young university. You know that in Italy we have old universities like Bologna University with 1,000 of years. But we have the other characteristic is that this university is an open university aimed to promoting a wider access. The students are very this university has been decreed as a decree of 2006 according to the strategy of open and online university that has been developed by Italian Parliament at the beginning of 2000. We have 11 courses. I hope that also in bilateral speech we can discuss some opportunities also of cooperation with your institutions. We have a course also in law, so this will be very interesting for us, for our students. We have the method of the teaching method that includes attendance sessions in synchronous and asynchronous based on simultaneity. The asynchronous and the asynchronous based on registration of the speech that we are doing here. We have a good e-learning platform, and I think that all the activity that we are starting here could be used also in future. Only going to the conclusion, I want to stress also that Università Mercatorum promotes a constant dialogue with other universities, and I thank here also the colleagues coming from other universities, as the colleagues that you will hear later, and with the systems of Chamber of Commerce of Europe. Only a few words about the team, but only a few words because Professor Firmanò will introduce, that is our scientific director, will introduce also the team. The team is the word competition. I'm an economist, and concurrence that was at the base of European market when European market was found in 1957 was based on concurrence. At the basis of concurrence, there is competition. Many years from them have presented to us many problems, and the problems of concurrence between the countries into Europe and of Europe against other countries. We are hearing something in these days that is very interesting and problematic, give a particular sound to our work, to our and to your work here. The rules are at the basis of competition, and the judges are the interpreters of the rules. So your work is very, very interesting, and it is not interesting for you or for us as professors of university. It's interesting for the enterprises, and it is interesting for citizens, because what does the enterprise as a follow-up on the citizens. Thank you to the steering committee that has done a good work. Thank to Michele Corleto for his work very hard, because it is not so easy to collect your experience here. Concluding, I hope that this opportunity to meet in Rome can give to you, but also to us, the opportunity of sharing contacts in next time, and to have opportunities to make a network that can implement what we call best practices, because only with the spreading of those best practices, I think that all of us can do a better work. I thank you very much, and I am sure that you could appreciate the work that has been arranged, and we meet this evening at the Cappella Sistina, and I hope the Holy Spirit will push on us. Thank you very much. And now the word to Professor Alessandro Bianchi, that is the Rector of Pegasus University.
Thank you, Rector Carnata. Scusa per... Sorry for talking with me. Okay, good morning, ladies and gentlemen. I'm very, very pleased to add my welcome greeting to that of Rector Carnata. As you know, the short summer school that you are attending was organized by the Mercatorum University with the collaboration with the Pegasus University. And this circumstance makes it possible to continue a working relationship between Rector Carnata and me. this relationship goes back many, many years when Professor Canata was the rector of University of Molise and I of the Mediterranean University of Reggio Calabria. I know this is a nice couple, no? Do you agree? Yes. Okay. Okay, stop jokes. I know that 31 judges from 15 countries are present here, and this is already an important fact in itself. But I think particularly important is the program which you participate. A program that the European community has launched for updating the language and the terminology of European judges, and especially to establish shared criteria of the competition law. In my opinion, this is a very important objective to underline the importance of European culture and identity. In my opinion, the countries that support this position are outside the ideas and values of a European community and should draw the necessary consequences. Since it is impossible to receive all economic benefits deriving from belonging to a community without respecting its founding values. Well, I will stop here and leave you to the meeting with your excellent teachers. Another cordial greeting for all of you, and wish of good work on the part of Pegasus University and myself personally. Thanks for attention.
And now the floor to Professor Francesco Fibbanò. Professor Francesco Fibbanò is a professor of law and economics, according to a cultural target that is in his brand. He's professor at the University of Molise, but here at our university is a scientific director. Please, Francesco, to you.
No, okay. Good morning. It's an honor for me to have all you here. Sorry for my typical Italian conflict of interest, because I am a scientific director of slides, and
mettiamo a schermo pieno così si vede meglio.
Mettiamo schermo pieno e vediamo come questa qua si usa così.
Procedi col tasto, sì.
Procedo col tasto, ok?
Next seminar will be on the impact of technology.
I am not a native digital, but it's better than you. As an artisan of law. Facciamo come dico io. No, ok, no.
Va bene così.
It's prefer. Okay. Okay. I think that is okay. Okay, welcome to all national judges of European state members, plus Albania. As I say, that I am a scientific director of Università Mercatorum and University Online Pegasus, which have organized this training for national judges in competition law, co-financed by Direction General Competition of the European Commission. I am also, and this is important because I say something about the function of the Terce Judicial, Italian judicial. I am also one of the 2 members of the board of Italian Court of Audit, President's Council named in particular, who were elected by Italian Chamber of Deputies of Italian Parliament as a full professor of commercial law and company law. The aim, the objective of this project is to enrich the skills of national judges with particular reference to the application of the new competition law legislation in a correct and consistent manner. But I can say something about the third Italian judge that is present in all European countries, that is the Court of Audit, that is the most ancient judge in Europe. Because this judge, as we will analyze, have a strange competence about this matter. So, our objective is to guide the training of a judge of all European countries plus Albania. I don't know if there is some judge of Albania, but it's necessary for the European Commission.
There is two judges.
Okay, welcome in particular to Albania judges. In the context of the application of the European competition rules, in particular with regard to the public and the private enforcement of antitrust and state aid rules, in order to ensure consistent application of European competition law by different national courts. This can be achieved through this project, which is focused in particular on the role of national judges in the application of European competition law, as well as on their particular needs, working environments, training, knowledge, and skills. Within the framework outlined by Directive 104 on private enforcement and the Legislative Decree number 3, 2017, which implements the former interrelationship between public and private enforcement, are traditionally linked to the relationship between the administrative antitrust assessment and the verification of such assessment with regard to the profile of the possible validity of the acts concerned and or the compensation for damage and or for issuing of emergency measures. So, the judicial players involved in such interrelation are basically 2 sorts of judge. The first one, the administrative judge, on the one hand, which is competent for the public enforcement phase with a peculiar full syndicate, about Professor, our professor speak about, on the violating case and on the interest sanctioning system, and the ordinary judge, on the other hand, which is competent for the private enforcement phase. In this regard, since 2012, Italy established the specialist ordinary judge for private enforcement. That is mine matter. It is commercial and company courts in Italy that have this competence. The demand for the declaration of the act's invalidity or for inherent compensation hardly ever comes into effect. We say standalone action, as the first procedure, public enforcement, appears to be a preliminary phase of the second one, private enforcement, in follow-on modality. Under this perspective, other judges, and in particular the third Italian specialist judge, known as Court of Audit, appear to buy outside that system of objective and subjective protection of market interests. This perspective disregards that the financial statement is a public resource. This is in Italy a relevant matter, is a public resource, is a public thing. And that due to its financial dimension and the service that depend on it, it is set within an articulated system of relations and interests that are related also to the market, as well as its tasks and fair competition. Indeed, accounting and the constitutional law have confirmed that financial statement and their balance are preconditions aimed at the protection of the community whose entity is exponential. The decisions also of this year there is in Italy an important decision that named San Valentino in relation at day on the Constitutional Court take this decision so as to avoid an indiscriminate and unsustainable growth of debt and expenditure, which would be expected to burden for generation and administration. Sustainability implies that the financial statement cannot be a disturbing element for the proper functioning of the economy, as sustainable debt frustrates the interests of supplies that are entitled to be paid regularly. The public budget must protect their interests in view of transparency of the spending process, but also their promptness and regularity, avoiding that in extreme cases, the same are paid in credit to spend in insolvency proceedings, compromising their own economic activities. In such cases, the Court of Audit may carry out a finding of accounting unlawfulness as well as a budgetary imbalance. Budgetary imbalance is a technicality of processing. Thus, break-even and effective measures, such as the budget freeze, in Italian, same blocco della spesa, budget freeze, are at the service of other core targets, including competition, with respect to which the budget is an instrumental public resource. But beyond this point of general interference, which concerns the phase of payment the financial statement can represent, for some market players, the assumption of monopoly positions in the provision of a service that relate directly to the management, as it occurs not only in the case of concessions for treasury service, but also for those of tax and public charges collection. In such cases, the administration, public administration, cannot be considered as a company that provides service, but rather as a central purchasing body on demand side. In other words, it cannot be considered as a market player, is a not market player, but more properly as a mediator of the competition in the interest of the market. The Court of Audit can in such cases ascertain lawfulness for irregularities which may result in a lack of truth and fairness of financial statement or of soundness of its balances, which charges the public administration with the obligation to announce a transparent and open demand that may allow as many companies as possible to compete in a monopolistic market. We will later discuss, Consigliere Sucameli is a teacher, the effects and the relations between traditional instruments in public and private enforcement. The enforcement of the legitimacy of financial report can, in fact, force the legal monopolist not to withhold and refuse to make available the big data that has developed during the service, thanks to concession, which farms fair market competition through the special, in Latino, actio ad esibendum, and incidental checks that may have the value of privileged evidence, both in terms of antitrust proceedings and private enforcement. This trading will analyze the leading cases and the law records and the potential outcomes in a case law that actually occurred before the Court of Audit in its role of judge of the financial report and in the institutional forms of the process jurisdiction. The Court of Audit have two roles. One is jurisdiction, the other one is audit, is two articles of Italian Constitution, and of the audit activity. In essence, the Court of Audit acts as a non-specialist judge who may, however, give rise to peculiar forms of public enforcement. In the field of private enforcement, we will analyze the following specific issue: the damage to competition as a damage to public property. Thank you very much, and is still welcome in Mercatorum.
Thank you, Francesco. Now I'm giving the floor to Professor Corleto, who will give us some information about the organization of this activity here. I want to stress also that the activity in the field of law and economics in this university will proceed in next days with a presentation here of a work on fintech. That is a presentation of a work very interesting that has been concluded these days. So the Italian colleagues that live in Rome who appreciate to be with us, I'll send to them all information. And please note that you are interested in follow the activities of this university. It will be very interesting because the seminar is a startup, and we hope that will be a follow in next times. Thank you. Michele, please. We are a little bit late, so please.
Yeah, very quickly. Yeah, thanks, Rector. Welcome for my part to all of you also, our Rector, and welcome to the all ECLJ Summer School participants. First of all, I would like to say thanks to European Commission that believed in our project, in our European project concerning training of national judges program of the European Union. In Italy, only the University of Macerata and European University of Florence have won and worked on similar projects. As coordinator of a steering committee, let me tell that it was a great satisfaction from a scientific point of view to contribute to the project and realize ECLJ Summer School. It has not been easy, of course, but very, very challenging for us and prestigious. Therefore, I thank our rectors, Professor Giovanni Cannata and Professor Alessandro Bianchi, and our scientific director, Professor Fimanò, for the trust that have in the project and for the trust that have in me. Not all these organizations could exist without our lighthouse, the director, Patrizia Tanzilli, also, and her work. For steering committee, it's a hug the development of project in the future for the next year. The purpose of the ECLJ project is to ensure a current and consistent application of EU competition law by judges of national courts, and also to create an European judicial network in competition law as a fundamental tool of effective application of available union instruments in the area of civil justice. We hope that the objective will be achieved following its specific training activities focused on the program that you have in your package. Welcome. On Sunday, we start with the focus on Friday, today, we start with focus on improvement of knowledge, application and interpretation of EU competition law today. Tomorrow we continue with our priority, the application and the scope of Article 101 and 102, and with our second priority, the application of competition law in regulated industry. On Sunday we will speak in the framework of state aid in modernization and the new enforcement role of national courts. The last day for us the most important because we also stress on the creative role of dialogue between the Court of Justice and national courts in balancing competition with the fundamental social rights. And also on Monday, we would like to continue the dialogue with you in order to the best manage for the next meeting in February. We want to receive to your parts many suggestions are expecting from you, debating with the judges Nicola Lettieri, Deputy Attorney General of the Supreme Italian Corte di Cassazione, and also judges of the Special Tribunal of Lebanon. The second goal of the project is also overcoming the geographical and linguistic barriers for creating a common European judicial areas. We will try to reach ancillary focus of our training program, in particular with legal linguistic training activities linked to the specific terminology used in the application of competition law, and also encouraging networking among direct judges from several member states in one specific terminology training. To realize this objective, to realize our program, also we utilize our advanced and innovative e-learning program available to the judges in order to creation of a discussion forum based on the topics of the lessons. It will be also set up a database of case studies and case notes, national law case studies, and EU competition law case. We will also want to create a legal glossary, common glossary, and other relevant documents with regard to training topics. A forum in which judges could interact by posting and commenting questions and exciting views on their experiences. And collection, of course, of relevant publication, including academic and scientific papers. Furthermore, all the judges, all participants will be invited to a final conference where we'll promote a worldwide exchange of ideas among national judges and government officials with interest in EU competition law. We strongly hope that this ECLJ project will fill the effective lack of coordination between the different national systems of the EU member states. Finally, Rector, and I'm concluding, I would like to say also, the last but not least, also thanks to the all staff members that work in this project, that was involved in this project, and a coordinator by our director. Enjoy your first summer school, enjoy Rome. Thanks for your attention.
Well, I think that you have to start to work now. Yeah. So, Professor Bianchi and I will leave the floor. I'll give the floor to Professor Cataldi. But before starting, I would like to have an opportunity photo with all you. So please come here, and we share there. Grazie, and we see you this evening. And personally, I'll be also on Monday. I'll give you the participation. Okay. Hi, Professor Cataldi. Good work. And if in the break you want to do a further visit with other part of the do not hesitate right there.
Mettimi il cartellino, ma qua non ci sono quelle. Sì. Bravo, pigliatelo sul bicchiere. Allora Michele, mi devi dire io quando devo... Sono le 11 meno un quarto, che devo fare? Devo fare una pausa, devo fare... Questo spegnere da solo passivo. Lasciami fare. Andiamo. In teoria, devo cominciare. Devo cominciare, devo aspettare ancora, vedi? No, ma non ci sta nessuno. Dimmi.
Due interventi sono ovviamente ininterrompibili, perché le spiego, io sono qui, però se fosse possibile fare così, se lei dice no, non si può aspettare.
Per ragioni di tempo?
Sì, io se recupero un'ora riesco a fare un'altra cosa.
Ho capito. Sì, vabbè, tanto io sto qui, non è una particolare fretta, dice. Solo che mi aveva detto Michele adesso di fare mezz'ora e poi di fare un break per il caffè 11 per un quarto.
Il break c'è comunque, io riprenderei dopo il break.
Se facciamo un time table,
se
diciamo.
Posso fare, se vuoi posso fare io qui subito intervenire, e tu fai tutti quelli che posso sotto.
Sai, a me è una cosa di carattere generale, non parlo di competition, parlo di quindi facciamo devo cominciare, poi però posso fermarmi e lasciare e poi alla fine ma non c'è un programma come questo, così lo dico pure a loro. Grazie. Good morning to everybody. I think it is time to begin because otherwise we will be too late with the program. I am pleased to give this introductory lecture to to the summer school. May I first of all introduce myself. My name is Giuseppe Cataldi. I'm professor of international law at the University of Napoli L'Orientale. I am the director of also of a project, European Union network project on migration and asylum law systems in Europe, and I am the president of the International Association for the Law of the Sea. I will not speak of competition, and so maybe someone of you will ask, well, what are you here for? According to the program, my task is just to give together with you, because it is my pleasure to speak to judges, to practitioners of law. My task is to give a general framework of the matter of relationship between international law, international supranational systems, so international order and European Union order, and domestic systems, with especially the particular focus on the role of judges. I hope it will be a sort of dialogue between us in order to have also a follow-up, I hope some questions, some intervention from your part. According to the, well, there is a little modification on the program, because I will now give a first introduction, a first lecture, then there will be a break, a coffee break, and then before my conclusion, Professor Biagio Giliberti will intervene on his topic on administrative measures concerning competition. And then after, I hope to meet you and conclude the morning, the first part of Monday program. So, some observation concerning the present situation of international governance, because international governance and so international order, international legal system is in the course of a sort of variation, a modification from the original framework, which was settled in particular after World War II with the United Nations system, and then with some supranational system as the European Union. Because the founding pact, may I call it like that, is has been modified by practice. You know, according to the United Nations system, we should have yes, Security Council, General Assembly, but also an Economic and Social Council dealing with general matters of social and economical reasons. But what is happened is that now we have the so-called G7, G8, G15, something which is not written in any of the founding documents of the international community after World War II. And in the Greek case, the well-known Greek case, we have seen the European Union cooperating with the United Nations institutions, but founding a so-called troika for economic crisis, which once again is nothing that has been provided by the international order in the founding days, may I say so. And also what we have seen during this period of austerity in Europe has been a sort of transfer to intergovernmental organs of competence which were drawn originally to be exercised by some organs, independent organs created by in the framework of the European Union. According to Lisbon Treaty, the Council, composed by chief of states and governments, should have a sort of role of general coordination, general strategic supervision. Now,
now, as we know, this council has a decisional role, and so, in a sense, European Parliament has been excluded, has been put apart of this decision-making process. I think we have to start from this also when we deal with important matters as competition law. Some other observation, general observation, you know, generally speaking, in Europe as well, out of Europe, states are in a process of defending themselves from what they have created. There are many examples of international treaties and conventions, multilateral conventions, which are on the way of being denounced, of being excluded from the participation of many states. This is not only a Brexit reasoning, and may I add that the Brexit from the European Union is not the sole example of contestation by the United Kingdom of international conventions. Also concerning European Convention of Human Rights, there is an attitude of refusing the main decisions of the European Court of Human Rights dealing with United Kingdom. There is a famous question on the detainees and the right of vote of prisoners. As you know, United Kingdom has refused to implement this European Court of Human Rights decision, saying that the European Court of Human Rights has not understood the technicalities and the roots of the United Kingdom juridical system. So this is, of course, it is not only the United Kingdom. There are many cases of this sort of attempt to escape from international obligation. Also, we in Italy, we have experienced this case of the so-called externalization of migration issue management. Externalization, which means trying not to have these people coming under the jurisdiction of national and supranational judges, so not coming under the jurisdiction, not coming under the need to implement international conventions as the European Convention on Human Rights, and how to reach this aim. Simply not letting them arrive under the jurisdiction, so making someone else doing the dirty job. This is the, in very poor words, the significance of the Italian-Libyan agreement for the management of migrants, and this is also the sense of the European Union Turkey statement concerning migrants coming from the West Balkan route. But the crisis, of course, is a very wide one. I can give many examples. I want to stop on it. May I say also that in Austria some months ago, there has been a speech of the chief of the government saying that it's not power to be subjected to law, but it's law to be subjected to power. May I also quote out of Europe the decision of Mr. Trump to denounce a series of international commitments, the climate one, but also others, of course. And there are the crisis also of, in particular, of the European Convention on Human Rights system. In many countries, we in Italy, we have experienced, for example, a decision of the Constitutional Court in 2015 saying that it is not compulsory to implement European Court decision unless they are Grand Chamber decision or pilot judgments, which is not written in the European Convention nor in the decision of the European Court of Human Rights. And also we have had a law in Russia now giving to Russian Constitutional Court the right to decide which decision of the European Court of Human Rights can be implemented in Russia and which not. We have the crisis, of course, in Albania. We have some Albanian judges here which can confirm it in Albania due to the reaction to some cases of corruption of judges. Now there is a sort of block on the Constitutional Court and the Court of Cassation of Albania, which is something very worrying. So there are many, many, many examples. What I want to stress is that concerning the international rule of law, rules are not different from what is the so-called domestic rule of law. International rule of law means that power is submitted to law in international law as well as in domestic systems. The problem is that many judges, many of you, have to face the problem of double standard. They have to face the problem that governments sometimes, and in particular in these difficult times of economical difficulties and difficulties of general values in general, governments intend the rule of law limited to domestic obligations, feeling themselves free to manage international commitments. This is the problem. And so this creates problems to national judges, to national courts, because they are exposed to the double-linked dilemma. Have I, as a national judge, follow in a certain way the position of my government, of my state, or defending my status as a judge and the separation of powers, have I to reaffirm the international rule of law, notwithstanding the position of my government? The rule of law in international as well as in domestic law means, first of all, that any power or authority is conferred by the law and controlled according to the law. In second place, that any illicit legislator's act is prohibited. This is important. Rules cannot be changed according to convenience. And many times we see that the legislator intervenes in a case beyond a judge which sees a private subject against a public subject in order to change the situation in favor of the second one. This is not fair. May I recall an interesting jurisprudence, and it's a case law of the European Court of Human Rights concerning the so-called prestidigitation législative, according to the French expression. So when the parliament behaves as a magician, there is an interesting case concerning Greek refineries and a Greek case where at a certain point there was an arbitral decision favorable to the private part, and the law intervenes in order to, generally speaking, but of course it was related to this case, it suspended the possibility of implementing arbitral decision in this matter. So it is a clear intervention of the legislator against the private part. And also in Italy we have had some examples of intervention of the legislator in order to cut the time, in order to reduce prescription, impeding private parts to go beyond the judge because time has passed. but normally it is 5 years. Okay, but this time it is 3 years. You are in the 4th year, you cannot go beyond the judge. It has happened in Italy, and we have had some European Court of Human Rights decision which condemned Italy on the point. Third point, concerning the rule of law, the exercise of power must respect fundamental human rights, which are compulsory according to general international law as well as conventional law. Fourth point, who is in charge of public functions has a precise personal responsibility. Fifth point, domestic systems must be organized in order to give to national courts the competence to judge governments acting in violation of international commitments, giving to any person remedies. 6, in the domestic system, national court act also as a sort of international orders agent, serving the international rule of law. This is the very famous doctrine in international law of a famous French he acts in the domestic system, but of course he has in a certain way the task also of making international law functioning. And I will give you in a moment some example to you. Of course, in order to make all this possible and functioning, what is needed is a system where the independence of judges is guaranteed, where the real separation of powers exists. You know, we have had the experience in many cases of the so-called mixed or internationalized tribunals, as in Kosovo, which is justified in order to try to have a tribunal which guarantees impartiality. So this is the problem. Where a judge is too much connected with a certain situation from a political point of view, he cannot act freely. That's why in a clear situation after a civil war, it is important to have this sort of internationalized tribunals. But normally, in normal situation, the judge should be left alone in deciding without any sort of connection with what happens from the political point of view. Problem is that states continually create menaces to judges' independence. Barriers still exist against the full recognition of the legal value of international law. These are the so-called avoidance techniques that avoid to treat international law as real law, to leave it to the foreign minister, which is not in modern times the real situation of what is really international law. May I speak very, very quickly of some of these techniques which must be refused, not only from the scientific point of view, but mainly must be refused by judges. First example is the so-called political question. The political question is a doctrine which has been created in order not to make judges decide. Sometimes they have been created by external powers. Sometimes judges themselves make reference to political question in order not to decide, not to have the responsibility to decide on some question. You know, there are some very old examples and there are some very new examples. The old and very known examples are in the United States during the Vietnam War when soldiers, when people refused to go to Vietnam saying it is an illicit war from the point of view of international law. It is a war of aggression. and what was the position of the military tribunals. I cannot follow you on this reasoning, because it is a political question. So I cannot say if it is or not permitted by international law this kind of decision by the government. Why not? Judges takes cognizance of the single case. So if a judge says no to a war, it does not impede its government to make war, because of course there is the separation of powers also in this sense, in the freedom of the executive powers to go on with its decision. But concerning the case under the scrutiny of the judge, it is important this assertion, this direct relationship with law and with international law made by the judge. The other example that normally is made is concerning some decision of the Conseil d'État in France, where in the 70s, where there were the nuclear exercises in the Pacific Ocean, and so navigation was impeded in this area, and of course companies had to deviate and had to lose time and money. And so one of the arguments beyond the Council of State, the French Council, was that nuclear exercises were forbidden by international law. And once again, the answer was question politique. It's a political question. We cannot deal with this reasoning. The problem is that also recently, this doctrine has come back again, and very frequently, because we are living difficult times. And so we see, for example, I mentioned before the Italian-Libyan agreement on migrant cases. There has been a recent decision of the Administrative Tribunal of Rome, challenged now beyond the Council of State. We will see what will be the outcome. The decision was, because there was a group of lawyers who challenged before the Administrative Tribunal of Rome the governmental decision to use funds for aids to developing countries in order to help Libya build the center of detention, the center where normally migrants coming from sub-Saharan Africa remain for a while. This decision of the government was challenging because it was, according to these lawyers, a sort of what we call eccesso di potere per sviamento, a deturnement of power, the use of a power for another task not provided by the law. And what the Administrative Tribunal said, it's an act of high administration, it's a sort of political question. We cannot deal with this argument. Now we will see what the Council of State will say, but I fear that the decision will be more or less the same, and I personally do not accept it, because I think that a judge has always the right and the duty to say the law, ius dicere, to confront the facts with the law, of course, with the limited power he has concerning the case under his scrutiny. And the same decision some years ago was the one of the Italian Corte di Cassazione, Cassation Court, when there was a request of some people for civil damages after the bombing of the Serbian television in Belgrade during the during the war by some NATO states, including Italy. And once again, when the argument was that it was illegitimate to go there and bomb a television tower where there is not only the state television but also some private television, so it was not a legitimate target according to international conventions on humanitarian law. The answer was, it is an act of high administration, I cannot deal with it. Okay. And this is the first of the avoidance technique. Other avoidance techniques are also common. For example, the general problem of judicial deference toward executive branch. The race of human rights should have put an end to this argumentation, but we often find that, for example, concerning immunities of foreign states or immunities of diplomats, there is a sort of deference of many judges in many countries, in some countries, to what the government decides, to what the government says. And this is another piece of legislation which should be left alone to the judge to decide. Different things are the diplomatic and political relationship of the state, and another thing is the judicial, the activity of a judge. Act of state doctrine. This is another avoidance technique concerning this time not what its own state decides, but what is decided by another state. Why should not a judge say, for example, that a foreign law is not legitimate, is not is an illegal one according to international law? Why this sort of deference to a foreign state? Of course, the decision of judge, it doesn't mean that this law disappears because it's a foreign law. But for the limited, once again, case under the scrutiny of a judge, there is no reason in limiting the judicial scrutiny of a judge. For example, saying that a expropriation, a decision of a foreign law to take all the goods of foreign people at home has been conducted in an illegitimate way according to international law. Why not? One other avoidance technique, very common, is the so-called one voice principle. I've already mentioned it. This pretension that please don't diversify your voice. If the executive has decided something, why the judge has to say something else? It is a dangerous attempt that, for example, we see in the International Law Commission of United Nations, where, as you know, international law is codified. According to International Law Commission, it is very complicated, and so they do not give reference to the practice of a state in verifying what is the content of a customary rule. If a state has different attitudes toward a rule, if we take the executive branch or the judicial branch. But I think this is the richness of a democracy, having the possibility to evaluate different point of view from different powers of the state. And now the most important thing concerning avoidance technique. The concept of non-self-executing international rule. the distinction between an international rule self-executing and not self-executing. You know, this distinction sometimes, many times, is made not with the intention of trying, as it should be, all the possible consequences from a binding rule, because we are talking of international rules, binding rules, customary rules or conventional rules, but in order to avoid international law enter in the domestic system and be applied. I make some very quick and very simple example. A non-self-executing rule is, of course, we have, of course, in the case of a discretion made to the state. For example, when in the United Nations Convention of the Law of the Sea, we read that a state can adopt a contiguous zone or an exclusive economic zone. Of course, there is no possibility of implementing this rule if a state has not made this choice. An international rule is, of course, immediately self-executing if it says no, if there is a negative content, if the object of the rule is saying to the states who have accepted this convention, for example, what they should not do. But in the other cases, it's up to the judge to verify how far he can go in implementing or not an international rule. For example, I give you an example. European Convention of Human Rights, Article 5 on right to liberty and security, last paragraph. Everyone who has been the victim of arrest or detention in contravention of the provisions of this article shall have an enforceable right to compensation. It is, of course, a compulsory rule because it is written in the European Convention on Human Rights, but its interpretation has been diversified for many years in some states, including Italy, because some judges have said, okay, yes, I am ready to give implementation to this rule, to give compensation to someone who has been the victim of arrest or detention, because it is written in the convention. But there is no implementing act from the legislator or from the ministry. So I cannot give immediate execution to this rule because I have no means, there is no proceedings put in place. So it is not a self-executing. Other judges have done a completely different line of reasoning, saying if it is compulsory, I have to make every effort in order to implement this provision. So yes, it should be better if a specific piece of legislation should have been enacted in my country in order to give the proper execution to this rule. But in the absence, I can, in my capacity, give the direct execution to this rule simply referring to the general rule of compensation in Italian civil code, but I guess in most of the civil code of other countries, there is a rule which says everyone who has done a legal act has to pay the monetary consequences. No, it's non-contractual responsibility. So Aquiliana, the famous responsabilità Aquila. So and many judges have given direct implementation to this rule also before a specific act of implementation made by the legislator. So this is the correct way in order to deal with supranational law. And the last example is the false application of the rule of the lasting time rule, the lex posterior principle. There is an important thing concerning supranational law, that when a supranational law rule, when international law is compulsory, has been enacted in a treaty, or if it is a customary rule, it is, of course, obligatory, compulsory, and this means that it contains two will. The first one is, of course, to provide to a specific regulation of the matter. The second one is to obey to international commitments. So, apart from all the domestic system of incorporation or not of international law into domestic system, apart from the differences in orders in order to deal with international rule, what it is important to say is that it should be never permitted to a subsequent domestic rule to go against an international compulsory rule unless there is the conviction, the perception that the conviction, the decision not to implement an international law. So what is important is that the explicit or implicit will of the parliament to go against an international commitment, which can be done, of course, because the parliament is sovereign, but there must be no uncertainty. And so it is very delicate, this point on the application of the last in time rule if there is an international rule, a compulsory international rule implemented already in domestic system. So this is the first part of my introductory lecture. Now we will have a coffee break, then my colleague will take the floor, and in the second part of my intervention I will briefly conclude on it, and I hope to have some follow-up with you. You know, this is a general introduction on the relationship. I hope in the second part to have the time also to deal with some specific point concerning European Union law, because as you all know, European Union law, when we speak of the European Union law, we enter another order, which is not the international order as such, is a new order, a different order, which is nor the domestic order nor the international order, but as such, as a specific order, it in a certain way has elements of the domestic order as well as the international order. So, of course, it's very delicate, very typical situation we have to deal with. Thank you. No, ma spero che a loro sia piaciuto, si vede un po' freddino in generale. Appunto.
Mi fanno da sparire. No, ci parliamo un po', vediamo loro che dicono.
Vengo.
So, good morning to you all once again. Buongiorno a tutti e benvenuti, benvenuti a Roma. I would like to spend some words with you about a specific issue, which is the control in full jurisdiction of the administrative courts on administrative measures concerning competition law. And I would like in advance this not to be just a speech of mine, but a chat among us. So I would provide you with some information concerning the state of our theoretical and case law situation about the power of control of the judges. But then if you prefer and if you wish, we can share information, and if you have questions, I would be glad if I could give you to you some answer. The point of our discussion would be the intensity of the control that the administrative judges can exercise over administrative measures in the field of competition law. In particular, reference will be made to the measure falling within the competence of our national agency competent for competition law, which is the Autorità Garante per la Concorrenza ed il Mercato, also called AGCM. Our issue is a constitutional issue because it concerns the real possibility for citizens to obtain an effective protection in the administrative process by means of a new understanding of the legal institute of the deference which the judicial bodies have to guarantee to the administrative authorities. I would immediately say that we are dealing with a situation in great turmoil, in great evolution, on which the historical weights of our traditional theoretical conception are still substantial and still tend to limit, in the name of the principle of the separation of power, the supervisory powers of the judges on administrative decision, both in terms of access to the facts and in the control of the administrative decision itself. But at the same time, it cannot be denied that that there is an increasing marked tendency of increase the control of the judge over such measure in name of the Article 24 of our Constitution, which guarantees the citizens the full right to defend their right or interest against any administrative decision. In the same time, very important for the evolution of our concepts has been the case law that we have from the European Court of Human Rights and from the European Court of Justice in terms of full jurisdiction and full access of the judges to the facts which have been challenged before themselves. I must also in advance say another thing. These issues are not just problems of competition law. These are general theory problems concerning the administrative law. And so the understanding of the dynamics concerning the relationship between judges and administrative competition measures can be correctly understood only through a reflection not confined to the specific field of competition law. For this reason, in the following, we will focus on general consideration regarding the power of the judges, and only then analyze the situation specifically concerning the competition law and the control of the administrative judges on administrative measures issued by our competent agency. Before analyzing all of this, I believe that one other clarification is necessary. It has always been possible, and it is still possible, to notice a discrepancy between the position of the same time, it is always induced to decide on the basis of factual circumstances, and in the name of this, in the name of the substantial justice. For this reason, it often happens that jurisprudence, when needed, tends to silently follow its autonomous road, and we will see what does it mean. So the best way to try to understand what is the situation currently in Italy is to analyze from where we come from and where we are trying to develop our administrative process system. And I must say that we will see that many things have happened over the time, starting from a situation where the control on facts were substantially prohibited to the judges, until up to the current situation whereby the power of control are increasing and increasing. We should also start from the first Italian legislation concerning the control over the administrative measures, which is the Legge Crispi. This law has more than 200 years, and so it's quite ancient, no? And whereby a distinction was made between a jurisdiction of merit and a jurisdiction of legitimacy, also called jurisdiction of annulment. The jurisdiction of merit was intended to be a fully and totally substitutive competence, whereby no deference had to be paid by the judges with regard to the authorities, and as a consequence, the judges could not only annul an administrative measure considered unlawful, but also define in the process the rule of law aimed to govern the future relationship between the administration and the citizens. So this was a special jurisdiction. This was a jurisdiction not general, but admitted only in few restricted cases. But on the basis of the circumstance that we had a special jurisdiction, it was believed by all in the doctrine, in the jurisprudence, and in the case law, that the jurisdiction of legitimacy would have been something different. The jurisdiction of legitimacy could not have been the same wideness as we have seen typical from the jurisdiction of merit. And so what was supposed to be this annulment and legitimacy jurisdiction? It was intended to be just an instrument for the judges to have the control on the deed of the administrative measure. The expression which was used is that the administrative judgment is a judgment restricted to the pure deed. The judge cannot have any access to the fact because the relationship between the judge and the facts are intermediated by the administrative decision, which the administrative bodies have taken into the specific deed which has been challenged. So, in principle, no access to fact, because it was believed that to judge an administration means to administrate, and this was prohibited on the basis of the principle of separation of power. Of course, this principle was just a principle, was not fully covering any possibility of control, but it was a fact that the access to the facts challenged was in any case intermediated by the authority, because if the judges had thought that something in facts was not acceptable as resulting from the deed and from the specific measure challenged, they had no way to directly access to the fact, but they had to ask the public administration to get clarification or get other forms of information just to decide. Quindi, in the end, with the expression judgment of legitimacy, it was believed that the jurisdiction of legitimacy was a special procedural investigation system in which the judge was fundamentally precluded from the faculty of considering the facts in a manner different from the intention of the administration, and in any case in which the revision of those facts necessarily passed through the clearings and the verification of the same administration. This is as for the excess of facts. As for the control on the content of the decisions, the judgment of legitimacy was qualified as a pure demolition judgment. This is to say, as suitable for the children, for the citizens claiming protection to obtain the sole annulment of the challenged measure and not necessarily as suitable to guarantee the final satisfaction of their interest. The final satisfaction of their interest would have been competence in second instance of the same administration which the measures of which had been challenged. This is for a pure application in the legislation and in the case law of the principle of separation of power. The judges just can have a general control on the legitimacy, but no more. Not take any specific decision and just annulment on the basis of representation of the facts given by the public administration. This scenario apparently very clear and in any case really consistent with some ideologies that were currently very whispered in the doctrine was nevertheless doubted in the light of the faculty of the judges to review an act not only for incompetence or for violation of law, but also in the name of the so-called eccesso di potere. We say excess of power, misuse of power, no? Through the excess of power, in fact, the administrative legislation was open to a form of control, of substantial control over the exercise of public powers, no longer limited to the findings of only formal illegitimacy, but to the correct unfolding of the administrative action from a functional point of view. The instruments where this concept, eccesso di potere, was specified in some other expression. Misuse of power, manifest injustice, unreasonability, unequal treatment, lack of instruction in the proceedings, lack of proportionality. Today we could say, through this instrument, the judge has a control not any longer just on the legitimacy, but on the merit of the decision of the public administration. Because if you can decide on proportionality, this has nothing to do with an external review of the act, but you go within the administrative measure, you control which is the balancing given by the public authority to the position of the citizen in respect to the position of the administration and other position of which have a role in the administrative proceeding. But nonetheless, we had this possibility, this material possibility in the process, but from a theoretical point of view, the possibility to have a control on merit was denied. Was denied on the basis of a dogmatic scheme, which was the following. We can distinguish between a portion of the administrative action which is entitled with discretionary power, and then we have the administrative merit. The first one, the discretionary power, summarizes all the relevant juridical competencies governing by norms and principles with the margin of appreciation to be fully reviewable by the courts and revisable by the courts. The second, the merit, was the place of evaluation, of political evaluation, of exclusive prerogative of the public powers, and for this reason, not revisable by the judges. Merit, therefore, as an area of institutional evaluation for political decision, for the choice between all legitimate solution, in the end, as an area left free for the appreciation of the public administration. So if I correctly explained to you, we start to see a sort of the discrepancy I highlighted before, no? Between some instruments that are penetrating in the judicial control of for the judges, but on the other hand, we still observe a sort of theoretical reconstruction which tries to put this innovative instrument into the framework of the past and trying to match between the needs of the citizen to get a much more deep form of control and the still very heavy weight of the separation of power and the relevant impossibility for the judge to somehow develop into a second instance administrative body. So, access to the control of the contents of the decision between excess of power, but in the same time, no great way to get the control of the facts, because the facts were a sort of word only for the public bodies. The only way to get the access to the fact were the possibility to ask clarifications to the same public administration involved in the proceeding and then in the process, or in the first phase. Then in the developing over the years, this possibility of get clarification has been allowed to be asked also to other public administration. The matter of fact was in the end that there was no way to get access to the process, to the administrative process of the so-called technical consultancy to be required to just a private operator, as you can, of course, do in any civil process in claims between private parties or in claims where also a public administration is a part. No, this is the main difference we can appreciate between the structure of the civil process in respect to the administrative process. Full access to the instrument of control the facts in the civil process, no other way to act to the facts in the administrative process. Instead, this clarification and specification to be required to the public administration itself. But then we started to manage with the European Court of Human Rights, with the European Union Court of Justice, and in the end also our national sensibility developed somehow. So in 2010 we had this very important reform because we had a totally new codice del processo amministrativo, administrative process code, whereby many things have been changed, and first of all, it has been definitively recognized the possibility for the judges to get the support of the technical support, to get technical consultancy in the administrative process. Now you have two different instruments. You can still ask to the public administration which are the facts and how they interpreted it and how they believe they are correct, so they get from them clarification. Or you have this typical instrument of the civil process, which is the technical consultancy, which the judge, in its discretionarity, can ask whether to private or public bodies and as it were in a civil process. It is important to pay attention to this legal institute, since around the possibility and the modalities of its use in the administrative process, much of the debate concerning the intensity of the judicial control has been concentrated. First of all, it must be remembered that the institute was admitted to operate in the jurisdiction of legitimacy in a cultural context in which the idea was that the administrative decisions taken by applied scientific knowledge tended to be intangible, being expression of convictions aimed at evaluating the public interest in concrete. So we had the instrument, but we still try to, we were used to get its support, having in mind the idea of a substantial intangibility of the administrative decision. So at the beginning, this instrument remained very, very used in only few cases and restricted cases, and it was denied the possibility to use this instrument very often in antitrust matters. Because, and the reason was that in antitrust matter, the high level of technical speciality, no? It means that no one except for the public administration, our national agency, would be competent to state what is a market, if in concrete there will be an infringement of competition, if in concrete there had been a misuse of competition. So we had the instrument, but in competition law, especially in competition law, it remained unused. This approach, nonetheless, has been revised over time. This primarily by virtue of the observation that this kind of interpretation risks to produce a substantial depletion of the normative solution, and therefore of the real capacity of the technical consultancy as an auxiliary instrument for the correct and lawful judgment. In fact, the impossibility to resort to technical consultancy does not allow a reconstruction of the facts underlying the assessment itself, which in turn, therefore, prevented the replacement of the judge assessment from that made the public administration. This opinion was mainly grounded on the arguments coming in Italy from the European courts. From this, in fact, came the indication that, on one hand, the judge access to the dispute facts can only be full. On the other hand, that the possibility for the judge to substitute its own vision on the dispute facts meets the limit of what is debatable. This is very, very common to see in the case law of European Court of Justice, whereby they say the access to the facts must be full, and there is and the judges are taken to review the administrative decision point by point. But then this same jurisprudence, the case law, at least as we interpret it in Italy, does not already believe that then the judge has a totally substitutive powers, because in case the situation still remain debatable, it's not any longer a matter of legitimacy, but it's just a matter of different opinions. If the judge has a different opinion from the administrative bodies, then it's just a matter of different opinion. It's not any matter of legal legitimacy, so the judge cannot annul the dispute measure. But in the end, the situation is, you can appreciate how far we are from the point where we started. No access to the facts, facts intermediated by the public administration in any case, and then we have a judge that can have full access to the facts. But there is another point. At the beginning, we distinguished between access to the facts and possibility for the courts to provide within the project the final rule governing the relationship between the citizen and the public administration, as if we were under the civil process code. You know that it should be, I suppose, a general principle that the one that within the civil process the conclusion of the process means that you will have a rule governing relationship within the claiming parties. Within the administrative process of legitimacy, the traditional idea has always been that the judge can just annul, destroy the specific act challenged, but cannot formulate any rule, because the public authority is still entitled with a discretionary power and is the sole body in the Italian institutional system which can administrate. So the administration cannot be a judge administration. This is our history. This is still, from a certain point of view, this is our history, because in the new currently Italian administrative process code, a distinction has been put between cases of discretionary power, whereby we mean political discretionary power, and also technical discretionary power. No? To stay to the distinction used in Germany, we can say that from one side we have Ermessen, and from the other side we have unbestimmten Rechtsbegriffe, which are technical begriffen, which are exposed to different evaluation, but and for this reason they are tending to be assimilated to the discretionary power. But nonetheless, what we have now in Italy we have this possibility. If we are dealing with an administrative measure which has no margin of discretionary power in terms of political consideration and in terms of technical assessment, then if the judge recognizes that the challenged measure shall be annulled, then he can not only annul the measure, but also provide the challenging parties with the rule of law governing their future relationship, so that the citizen can get from the process everything he has not received from the administrative proceedings. This only with the limit of discretionary power. If the public administration is granted by the law with discretionary power, then the judge must stop himself annulling the dispute measure, and the citizen will get, in the case, satisfaction only from the reuse of or repetition of the administrative proceedings. No way to get more in the process. Of course, this between these two different situations, we have the practical case law, because administrative judges often say, okay, I cannot get the rule, I cannot provide the citizen with the rule, but as I am the subject competent to interpret the law, I can annul, but I can somehow suggest to the public administration which will be the rule of law that they must follow to come to the solution. So we have a sort of execution phase in the annulment process, which is not a totally a pure execution processual phase, but it's say in between. No, you can get the measure you want by me, but I can suggest the administration to decide, taking into account some general principles that in concrete can really be very strict and to be followed. So summarizing in few points what emerged from the exam of the Codice del Processo Amministrativo, it can be said on the one hand that there is a conspicuous increase in the effectiveness of the protection offered to the citizen by virtue of the strengthening of the cognitive instruments and the maturation of greater confidence in the recourse to technical consultancy. Moreover, the passage from the original solutions of Legge Crispi and the Codice del Processo Amministrativo did not lead to a possibility of full reviewing the administrative measures by the judges, which are still limited to annul in case of misuse of power, manifest unreasonableness, defect of proportionality, where in case they not state that an administrative measure has been totally gone against this principle, then we are, and I repeat, always in a matter of different opinions. And the different opinion is no way at all nothing to do with a legitimacy problem and with the possibility to annul the challenged act. Of course, in concrete, if you recognize to the judges such high possibility in terms of access to the fact, in terms of evaluating the administrative measure by means of proportionality, just to state an example, of course, this is to the judges to be always very careful not to infringe, which is still a principle of under our legislation, which is the separation of powers. So this is a matter of fact. But this is now today we can say this is in the hands of the careful capacity of control of the judges, and not any longer something to them prohibited because of the denial to the access of fact and or in the light of a deference to the administrative body to be interpreted as in the past. What happens in this moment in the specific field of the competition law? First of all, the administrative process jurisdiction on the measures of our national agency, the AGCM, is split in two. We have from one side the jurisdictions on economic sanction, on fines. In this case, the jurisdiction is totally full. This is a merit competition. It means not only they can annul a fine, but the judges can redetermine in the process the level of the fine, and they can both make it higher or then redetermine it in less. But this is in the end still a sort of exception with regard to the general powers and possibility of the judges in respect to the AGCM, because except for this merit jurisdiction, we have a pure legitimacy annulment jurisdiction. This jurisdiction is, and we must highlight it, has become much more important as in the past after the transposition in Italy of the European Union directive concerning the public and private enforcement. Because today, a decision taken by the administrative judges is a decision that somehow can have influence or determine also the definition of civil trials among private parties. So it means that this is very, very, very important, this jurisdiction, for the consequences that it can have on also on civil trials. But given the above, we can move from two considerations. The first is that no, I already said the first one because it concerns the sanctioning power. The second one is that the administrative judges have historically shown particular deference to the decision of the AGCM due to their high rates of technical complexity, for which it has been talk of technical distraction, and the theories of the total immunity of the administrative body has been applied in this specific sector. However, this is a position that has been subject to review, and nowadays is very often to read a decision of the administrative judge of the Supreme Court, il Consiglio di Stato, where it has been stated that even the evaluative and complex elements of a measure taken by the Autorità Garante per la Concorrenza del Mercato are taken in consideration in the norm in the objective dimension of the historical fact. This historical fact can totally be reviewed by the court. It means that the court can get within the fact and not only stop itself once they have stated that from a general point of view everything sounds reasonable. They can provide a fact-by-fact control determining in concrete the semantic extension, for example, of a typical institute of the competition, where what is a relevant market, for example, so they can have full access. On the other side, once they have full access to the facts, it does not means that they can, for this reason, have a jurisdiction of merit and review the position. They can only review the position in case they ascertain a misuse of law, error in the reconstruction of facts. So in this sense, the limits of the jurisdiction of all legitimacy are confirmed under AGCM culture. In my opinion, this is enough to provide you with a first picture of what is currently happening in Italy. Of course, if you have questions, I can, and if I can answer to you, I would be glad to do this. And if you, on the other side, would tell us something about your jurisdiction, where we are somehow in the same way, in the same point, or you can remark difference, it would be interesting. So this is up to you.
Any questions? Nothing for you. No. Okay, nothing for you, Professor Giliberti. Thank you a lot for your relation.
Thank you very much to you. Have a nice stay in Rome, and I hope to see you again in the second part of this. How many?
3 days until 7 October. Yeah.
I suggest if you next time we meet, if you have specific questions you want to talk about on this issue, let's write to us, because then we can get much more concrete and answer to your sort of questions or curiosity about.
Okay, thank you.
Once again, arrivederci.
Bye. Now we start with the second part of the lesson of Professor Cataldi on focus on supranational law and domestic system, the role of national judges. Please, Professor Cataldi. So I go on with what I was saying before, that is, in particular, the relationship of domestic judges with the supranational order, and in particular, more in particular, the relationship among different juridical orders, because we have to approach to the European Union order in order that my colleagues will develop their own
lessons concerning, in particular, competition law. I spoke before about the limits to the autonomy of judges in determining the rules, international law rules in particular, limits posed by the order, by the executive, or self-imposed by judges themselves. Now, let's give a look to the question, the important question of the so-called counter limits. So the relationship among orders that develops when the normal limitation of domestic orders given by the need to implement international rules meets a wall, a limit in the fundamental principle of the state. You know, international law and European Union law as well is always a limitation that states have decided to impose to the normal functioning of the domestic order. It is a very old theory that is one of the self-limitation. A state limits itself, limits its sovereignty in order to develop relations with other states, in order to develop an international order or a supranational order like the European Union law. This is the normal functioning of supranational rules. But is there a limit to this limitation? This is the question of counter limits. The question of counter limits, which is very important when, for example, fundamental human rights are concerned. And we have an important example of this. You know, at the beginning of my speech, I was speaking this morning of national courts acting also as international orders agents. And now I want to give you a precise example of what I mean. You know, for example, in the famous decision, Cadi and Al-Barak versus Council and Commission of the European Union Court of Justice in 2006 or 7 decided in this famous decision not to follow supranational law, international law. In particular, there was a decision of the Security Council of the United Nations imposing the famous lists of suspect terrorists. And so there was the need to implement this decision with domestic law as well as in the European Union law regulation. Domestic for European Union order law is regulation, directives, and so on. So the Security Council decision did not provide judicial scrutiny, judicial control of this inscription of a list. If my name is inscripted on a list of suspected terrorists and my bank account is blocked as a consequence, according to Security Council decision, there was no possibility for me to go beyond a judge. And so the European Union Court of Justice decided that this was illegitimate according to fundamental principles of European Union law, and decided that always must be scrutinized, always must be subject to the control of the judge a decision of this kind. So in a certain way, it did not implement or implemented in a different way a decision which came from a superior order, which is the international order, which is the United Nations order. Someone criticized this decision because, according to some opinion, you cannot implement superior norms in a sort of menu à la carte. You choose, you pick and choose, and you decide if there is a sort of hierarchy. But the real juridical argument is the one of the counter limits. So European Union law is subject to United Nations law because Security Council resolutions, they have a widespread compulsory value all over the world, but always an order has to defend himself when fundamental principles of this order are challenged. But if these fundamental values are consistent with international law, this is the point, because, you know, you can always say that your own domestic system has a fundamental value, and this could also be a sort of excuse not to implement law. Think of Sharia principles. I have nothing against Sharia principles, but you cannot say that they are a common heritage of humanity, fundamental values recognized by international law. They are limited to a particular group of states, in particular the ones which interpret in a strict, rigid and conservative manner this principle. So I have some difficulties in recognizing these fundamental principles as principles in a certain way guaranteed by a widespread feeling of the international community. In the case of the European Court of Justice decision, we have the affirmation that the judicial control of fundamental rights of a person are an heritage, a patrimony, a good that cannot be the subject of a sort of dealing, even if when there is a superior decision. So this is the difference between the evaluation of principles as Sharia principles as fundamental values and in the case of the European Court of Justice decision. Another interesting case concerning fundamental values, also disputable, there are very diversified opinions on the point, where in the famous decision of the Italian Constitutional Court number 238 of 2014, when the Italian Constitutional Court declared the impossibility for the Italian order to implement the International Court decision which condemned Italy for its jurisprudence on civil damages for people that in World War II, of course, for the heritage of these people, for sons and nephews, during World War II were deported in Germany and condemned to forced labor. This is an interesting decision because the Tribunal of Florence, now once again it is important to have had a judge with particular sensitivity, because the Court of Cassation, even if it was contrary to International Court of Justice decision, accepted to implement it because it was the International Court of Justice and because there had been an Italian law compelling judges to reopen even in the cases of res judicata, all the cases and give effect to this decision. The Tribunale di Firenze went beyond with a preliminary ruling beyond the Constitutional Court. What was the case? The case was that the International Court of Justice said that the Italian jurisprudence was against the customary rule on the immunity of a foreign state from jurisdiction, because, as the International Court of Justice said, all over the world there is this rule that, first of all, verifies if there is the competence and then passes to the merits. So, according to the International Court of Justice, yes, these cases, this hypothesis of forced labor during World War II, yes, they are jus cogens principles. They are at the top of the hierarchy of international crimes, of course, but as a preliminary ruling, the correctness of the action of the judge is to verify if there is immunity or not. And according to the practice all over the world, there is immunity in these cases. And so a domestic judge has to decline its competence. The Tribunale di Firenze asked to the Constitutional Court if implementing this decision should not be against one of the fundamental principles of domestic Italian system, that is the one which is codified in Article 24 of the Italian Constitution, the principle of a judicial scrutiny, the judicial control for every right or legitimate interest. And the Constitutional Court said, yes, it is like that. So it is, of course, we have the duty to follow International Court of Justice because there is the Charter of the United Nations, there is an agreement in order to have this decision implemented, but there is a wall which cannot be overcome, that is this fundamental principle. What is justified, in my personal opinion, what justified this decision is the fact that this fundamental principle of our constitution, of our judicial system, is all over the world perceived as a fundamental value. Because these people remain without a judge, because they went beyond the German judge, and the German judge said, no, after World War II we have closed all this situation with the international agreement. We have recognized our responsibility also from the civil point of view with the states, so the question is closed. Italian judges had to close themselves to these actions due to the Italian law and to the International Court of Justice decision, so no possibility left to these people to give effect to this important, paramount rule of our system. Many were, of course, the critics against this decision, this Constitutional Court decision, but many were also the critics against the International Court decision, because the International Court decision correctly verified the practice of the states all over the world in order to determine the content of the customary rule. But not a word was spent on human rights questions and also on the problem of having a jus cogens rule not to be implemented as a consequence of the need to treat the immunity from jurisdiction rule as a preliminary rule. So it is really a complicated issue, also because it was a case beyond the International Court of Justice with two states pertaining to the European Union, two states which were at friendly relations. So it was, of course, a complicated issue from the political diplomatic point of view as well as from the juridical point of view. And it goes on, because at the end of the day there was a sort of silent agreement, because Germany accepted to establish a sort of fund in order to help some people. So there was a sort of solution found among two states with friendly relations. But remains the fact from the technical point of view how to solve it, which is the best solution. But what is important in this case for our task is once again to verify the problem of the clash sometimes among two different orders, and this difficult category of counter limits, which is important also for European Union law, and I pass to European Union law. Because also in European Union law sometimes we have this possibility and this difficulty in putting together the two different orders, the domestic order with the European Union law order. We have, of course, a difference, an important difference, because European Union law compared to international law order is much more, how can I say, sophisticated, much more grown up in the decades. We speak of the European Union law as a sort of international law successful, international law which managed to create an order which a really system of compulsory, not only of compulsory rules, but also of efficiency in the affirmation of its value, always in domestic system, not only for judges, but also for governments and also for parliaments. It has been difficult at the beginning, but now it's like that. But anyway, also in the European system, we find sometimes these difficulties. We have had a famous case which also regards Italy, but it is known also out of Italy, which is the Taricco case, a case where there was the problem of, from the side of the domestic order, to respect terms concerning prescription, in particular in the light of the protection of rights of people under criminal proceedings. We have had some problems for Italy beyond the European Court of Justice, but also beyond the European Court of Human Rights, for the time of prescription, for the interruption of prescription in many cases, because actually there is a problem in Italian system concerning interpretation. But there is also the general principle of the favor rei, of the need to give application to law and decisions to people under criminal proceedings in the most favorable way for the person. On the other side, we have the European Union system, and according to the European Court of Justice, the need to protect the financial interests of the European Union at the maximum extent. So what happened? It happened that European Court of Justice, in its first decision, asked to the Italian system. There was once again a preliminary ruling coming from the Tribunale di Cuneo to the European Court of Justice, and the European Court of Justice said that Italian law should be not be applied in order to give this protection to the European Union interest, to economic interests of the European Union. The problem was that in following the European Union Court of Justice decision, one should be in a certain way renounce not only to the Italian law prescription, but in general to a general fundamental principle that is the favor rei principle, which is one of the fundamental principles of our system. So once again, a sort of counter limits question was at stake, but happily, the Italian Constitutional Court, once again, with a preliminary ruling, asked to the European Union, please tell me what should I do, because, you know, I am a Constitutional Court, so I have to guarantee fundamental rights. So what is the real content of your decision? And in the second decision, 2017, the European Court of Justice was more open, may I say, to the reasoning of the Constitutional Court, saying, okay, it is up to the domestic system to guarantee the financial interests of the European Union, but also to respect fundamental values, and it will be for a question for the legislator, for the parliament, to enact rules which would be in a certain way consistent with this European Union principle. So there is a clear message to change the rules in Italy in order to be respectful of the European Union system. But in the meantime, European Union Court of Justice in a certain way accepted that for the moment the situation stays as it was. So I think there was a fruitful dialogue among the two courts, because you must always remember, but of course it is useless to say to these two judges, that in every order the Supreme Court has the final word. So if we speak of the European Union law, it is evident that it will be the European Court of Justice to have the final word. But also in a constitutional system, there will be the Constitutional Court to say the final word. It's its own system. Everyone is the judge of his order. So the problem is when there is a clash, a difference in opinion, in position, and also a difficulties in putting together the rules of the two orders, how to solve all this. But of course, this is the may I say, the interesting part of the history. Another point I want to stress concerns the problem of reopening of cases after res judicata has been formed in the domestic system. I have already said so concerning the problem we had in Italy when the International Court of Justice condemned Italy for its jurisprudence. A law was enacted in order to permit the reopening of this situation that were definite from the point of view of the domestic order. A specific law was enacted. This law was challenged beyond the Constitutional Court. The Constitutional Court said that the law was against the Constitution for this clash with Article 24 of our Constitution on the right to a judge, and also the law implementing United Nations, Italian law, giving execution to United Nations Charter in the domestic system, was declared contrary to our Constitution for the part in the part that it gave the possibility to the National Court of Justice to introduce in the domestic order a rule against the fundamental values. Someone was in a certain way astonished. Italy is abandoning the United Nations system. No, it's not that. It's only a technical way to say that this decision was not executed in Italy. Anyway, concerning the reopening of domestic cases, processes already covered by the res judicata, principles, there is a difference if we look at the system from the point of view of the European Court of Justice, of the European Union law system, and from the point of view of the European Court of Human Rights system, European Court of Strasbourg. From the point of view of the European Union law, you know that it is a rule well established now that any form of res judicata in the domestic system has to be reopened without any problem if this is ordered by the European Court of Justice. We have a lot of decision on this point, the case Kobler, the case Kuhn and Heitz, Kempeter, Traghetti del Mediterraneo, Lucchini, Olympic, there are many cases in which the European Court of Justice has said that it is a principle which is deduced from the primacy of the European Union law respect to a domestic system, that if a challenge has been made beyond the European Court of Justice, which implies the decision of the Court of Justice implies the reopening of the process must be reopened. There is no possibility of excluding it in domestic systems. On the contrary, in the system of the European Court of Human Rights, we have not reached this stage, not yet, at least. We have had some famous cases concerning various states. Of course, I know better the cases concerning Italy, and I make reference to them. And what we have seen is that in many states, member states of the European Convention of Human Rights, a law has been enacted in order to give this possibility to judges, in order to say that if a process has been declared by the European Court of Human Rights contrary to the European Convention, the case must be reopened even if it is covered by the res judicata, if it is definite. In Italy, we have not yet a law on the point, even if the Constitutional Court has in a certain way pushed the Parliament to enact this law, but a law doesn't exist. What exists in Italy is a jurisprudence of the European, of the Constitutional Court, concerning only criminal cases. The decision number 113 of 7 April 2011, in which the Constitutional Court said that our code of criminal proceedings is completed by an absent rule which the Constitutional Court poses. That's why this kind of decision is called sentenza additiva, a decision which adds something to the system. This rule of the criminal proceedings concerning the reopening of process has to be considered added with the rule that says that if there is a decision of the European Court of Human Rights which says that a process has been conducted contrary to European Convention of Human Rights, it is compulsory to reopen this process as a guarantee for the detainee, for a criminal, someone who has been condemned for a criminal fact, in a criminal case, but with the process considered in violation of the European Convention. The same rule was refused by the Constitutional Court in civil matters, which from a technical, well, one could say, okay, criminal matters are sui generis matters, so it is normal that they have a sort of preferential, how can I say, way of dealing with human rights. But from the theoretical as well as the technical point of view, it is difficult to say a real difference, especially in some cases which have been treated by the Italian Constitutional Court concerning minors' rights, but in civil matters. The Constitutional Court did not accept to make the same decision, to, in a certain way, say the same thing, adding to the code of civil proceedings a rule on the reopening of a case where the case has been defined according to domestic jurisprudence. So this is an issue. One other important issue is, we have spoken so far of res judicata, let's speak of res interpretata. That is, if there is an effect of the international decision out of the case, out of the parties, you know, because normally a decision of a judge is compulsory for the parties, but not goes its effect beyond the parties. According to the European Court of Justice, as you may know, the decisions of the European Court of Justice are compulsory, are obligatory also for states which are not parties in the case. So they have an effect of res interpretata. They oblige also other states. The principle is common to everyone. So it is not something which is important for compulsory only for the parties, only for the state convened, but also for all other members of the European, or all other state members of the European Union. Once again, this is a specific value, may I say, of the European Union system, because for other international tribunals, there is no effect of this kind. There is no effect of this kind, in particular for the European Court of Human Rights. The European Court of Human Rights has tried in many cases to, how can I say to the judges, please take care of my jurisprudence, notwithstanding the attitude of the executive or of the legislator. May I recall, for example, a case against Belgium, the famous Merckx case, which in the 70s declared the Belgian law on succession, which did not parify the children out of the marriage to the children in the marriage, against the European Convention of Human Rights. 20 years after, the same case arrived to the European Court of Human Rights. The European Court of Human Rights condemned, of course, Belgium, but added in the decision a sort of message to the judges saying, okay, I condemn Belgium because in 20 years it had not modified its legislation, but why domestic judges do not follow directly my jurisprudence? Because according to the Belgian system, as well as to other systems in Europe, if a rule is compulsory, in particular European Court of Human Rights, according to the jurisprudence given by the European Court of Human Rights. For example, in Italy, Constitutional Court said in two decisions of 2007 that the rules of the European Convention of Human Rights are compulsory for the Italian domestic system according to their content as interpreted by the European Court of Human Rights. So there is this message to the judges to, in a certain way, respecting domestic system, but not taking care of what the legislation, the parliament did not do and was obliged to do in a certain way. I know there is some difficulties in a judge who has, in principle, to apply, to implement the domestic rule, to put apart domestic rule. But if its own domestic system gives him this possibility must be exploited. But the European Court of Human Rights went also further because, for example, in a case against Cyprus concerning the violation of European Convention on Human Rights because there was a law still criminalizing homosexual relations among adults, Modinos versus Cyprus. The European Court said, in 1981, I told the same thing. I said that a legislative ban on homosexuality relationship is against the convention. And I said it in a case concerning the United Kingdom. Why did you not follow this decision in your system? Why did Cyprus did not conform to this decision, even if it was for the United Kingdom? And why not Cyprus judges did not follow this decision? So there is this attempt of the European Court of Human Rights to give this strong effect to its jurisprudence, which in a certain way we can already, in many, I don't think in all, but in many domestic systems of the European state members of the European Convention on Human Rights, we can also deduce from the functioning of the domestic system. But this is up to you, to the judges, to the domestic system, if they can and if they want to follow the European Court in this reasoning. Of course, it is not compulsory. The European Court of Justice is compulsory. This is the difference which is really in the two systems. Let's close with now with some quick, because I have to, in a certain way, open the door to who will come after me, and of course open the discussion and the discourse on the reasoning on European Union law on competition matters. I told you before that in a certain way we can consider European Union law as a sort of international law successful. Why? Because what is clear in European Union law that there is very little discretion in domestic system concerning the execution, implementation of European Union law. European Union law has direct effect, as you know, not only for what concerns regulation, but also for concern directives and decisions, of course, for the part that it is possible to directly implement. The reasoning is always the same. If a rule is compulsory, it has to be implemented. How far can it be implemented? It depends, of course, of the writing, of the content of the rule. But it depends also on you, on how you are ready. What is your disposition? What is your position towards a rule which comes from a different system, which is not your own system, but according to your own law as this primacy over domestic law. So, in the case of the European Union law, this supremacy and this direct effect they come together. There is direct effect and there is supremacy. So it is easier to give this direct effect because there is supremacy. You know, I always make the difference with the European Convention on Human Rights because actually the problem is that the European Convention on Human Rights has supremacy but in a different and in minor way that European Union law. Here you have direct effect, supremacy, res judicata, res interpretata, as I told you. Of course, it depends on the position that the judge has in its own system how to deal with this law. You know, in Italy, for example, after many years, but of course now the time has changed, now judges have confidence with European Union law and there are not many problems in cognizance, in knowing it, in implementing it. In Italy, as well as in other states, the problem now concerning the direct effect and supremacy of European Union law is in the administrative offices, in ministries, in functionaries. This is the difficulty. Why? Because normally the judicial power is autonomous. The judge normally is autonomous, even if it's a first instance judge, is not conditioned in a heavy way by the second instance, by the cassation and so on. Functionaries are different because they are hierarchically organized. You know, I have to very quickly, I want to give you an example of something which happened to me personally. Some years ago, I was contacted by an entrepreneur in my city, Napoli, who was importing in Italy strawberries during winter from Argentina. So a ship had to come in the Napoli harbor from Argentina with strawberries in January. The problem was that there was a directive of the European Union which forbade the importation of these products during winter. So that it was not possible. But Italian and French dealers with these products obtained from the European Commission an exception, a decision of the European Commission which opened a window of 15 days, 20 days, in order to have these goods imported. The directive which said no, you cannot import, had been implemented in Italy by a decree, a ministerial decree. The decision was not implemented by ministerial decree. It was on the official journal of the European Union and stopped. From the point of view of the law, there is no point in implementing these rules because they were self-executing. Directive saying no, it is not possible. A decision which says of course after in a time subsequent to the directive, saying as an exception to the directive you can import. So it was very clear, it was self-executed. There was no need of domestic implementation. Because if you read the domestic implementation of the directive, it was the same text which was copied and pasted in a domestic piece of legislation. So the poor man who asked my intervention said, please try to convince the official of the custom that now the rule is changed. Now we have right to import this. So I went to this official and I made a lesson of European Union law saying you must know that there is self-executing, the direct effect, this is, they have the same hierarchical value, but, you know, lex posterior, and so the decision prevails. And the man looked at me, said, okay, thank you very much, but I have a ministerial decree signed by the Director General of my own administration, and I will never go against an act signed by my superior. What to do? I of course, opted for what we call in these cases an Italian solution, a soluzione all'italiana. I knew that in the Ministry for European Union Affairs, there worked as a consultant a colleague of mine, a friend. So I called him and said, please, let the ministry or the Director General sign another act, stupid act, useless act, but it is necessary because otherwise we will never solve this situation. I explained it. I said, okay, don't worry, tomorrow morning you will have this act. You know, I understand the man, you know, because the administrative order is like that. It's vertical, it's hierarchical. So it is difficult to make them act in a different way, taking on its burden the responsibility to make this sophisticated juridical reasoning and giving direct application. But what is needed by an efficient European Union system is exactly that. So what is really important is your own attitude, your own decisions, because in a certain way they will help the administration, because today the man was very reluctant. Tomorrow maybe having some many decisions of this kind of tribunals, he can rely on a. So really what is important is the not because I want to be kind with you, but it is the attitude of domestic justice toward European Union law. I finish with 2 words on the European Union antitrust law, only to say that also here, your action is very delicate, because, you know, there has been in the past a huge, once again, different of position. Now it is overcome, it is history, but it is interesting notwithstanding that, because the role of the European Commission, which was a paramount role, mainly at the beginning of the system. Now it is always like that, but the system is changed. The role of the European Commission was not perceived as a judicial role by the European Union system, in particular by the European Union Court of Justice. You know that the Commission in the antitrust rules has a role of police, of a controller, of a judge, of everything was in the end of the Commission. Now it's less. But the European Court of Justice said, no, but it is not a judge, so it is not fair to say that you have to respect some principles, in particular right to fair trial, according to Article 6 of the European Convention of Human Rights. On the contrary, the European Court of Human Rights says that it is the nature of the decision itself which resolves the dilemma of applicability of Article 6. It is very important. It is not the organ as you can define it in the treaty or in another document. It is the kind of proceedings, the kind of decision that in a certain way tells us if the rule of fair trial is applicable or not. And on this different of vision by the two courts, at the end of the day, there was, in a certain way, the acceptance of this applicability of Article 6. Now, the situation has changed, and of course, there is more national power in implementation of Article 101 and Article 2 of the treaty for what concerns competition. And this important role that as national authority, that have national authorities in general domestic system, is very important, but which is the risk? The risk is jeopardizing uniform application of these articles, because of course if more room is given to domestic system, maybe there will be differences of visions on the point. So if we give a global look to national legislation on the point, we have the idea, we keep the idea that the national legislator has in a certain way not given total independence from the executive to the judges, because you have an important role of the so-called authorities, so which are administrative organs. So once again, it is up to you, up to the judges to, in a certain way, assure a sort of uniform application and interpretation of antitrust law in the domestic systems. And this should be, in my humble opinion, your efforts in your daily work on this matter, and not only on this matter, of course. And so your presence here in this discourse maybe is a good promise. It's a good, I think, initial path to all this. So really, I am happy to have had this possibility to be there, and may I also say how important has been for Mercatorum University to win this project, to conduct this project, thanks to all of you and all of them, all of the group who made this possible, in particular to Dr. Michele Corlito. Thank you very much. We have 10 minutes more. If someone of you wants to take the floor, want to say something, or to add, to ask something, or to make some reflection, of course, it will be up to you to intervene or not. Questo mi ha visto?
Sì.
Mio, sicuro?
Sì, Any questions? No. Ok. Possiamo andare a mangiare? Okay, thank you very much to Professor Cataldi, and now we have a little break for the lunch. At 3 o'clock we restart the seminar. I invite you also can visit a little bit the square, very nice square in the little district here. And at 3 o'clock we start again, okay?
I don't know if you know that we are in the Roman ghetto here. So it is very interesting because there is this Hebraic presence, very old one, very ancient one, 10 meters from here. So you may also visit the Portico d'Ottavia, which is very interesting.
The important that at 3 we restart, okay? Don't lose. Please go. Passa molto bene, spazza la grande, mai l'abbiamo registrata questa.
Senti, io poi ti lascio tutto a te però mi raccomando non sia mai, non mi perdersi cose perché sono tutti appunti certo non me li porti in Portogallo questi cose. Mi dispiace, ti do questo peso. Pure la povera a dire. Non ci da fa su sforzo a Martino.
Yeah, you can leave all that you want here.
Sì, mi sto fregato così. Sì, grazie. Sì. Ma voi dove state? A Napoli? Ah, che sezione? Ah, bene.
Diciamo è stato anche un po' nuova per noi, questa materia è un po' nuova.
Sì, certo. Io poi diciamo sinceramente di diritto della concorrenza non è che ne capisco molto, penso si è capito perché parlato di tutt'altro, però mi avevano chiesto di fare un'introduzione generale perché io mi occupo molto di rapporti fra ordinamenti, cioè io sono internazionalista, il mio maestro Benedetto Conforti era quello che un po' diciamo come dire, ha trasmesso questa idea del diritto internazionale come diritto tout court, come diritto da far applicare ai giudici, eccetera. E io mi sono sempre mosso in questa linea, insomma, sia nella mia produzione scientifica, sia per la mia attività, eccetera. Quindi mi occupo molto di questo, di rapporti fra ordinamenti.
Sì, infatti.
Ho dovuto tagliare molte cose, ma insomma comunque.
Dobbiamo farle complimenti.
Siete molto gentili, grazie. Arrivederci. Comunque ci vediamo dopo. Sì.
Yes, it's confirmed. We have sent you the correct flight ticket because the agency did send you a wrong ticket. And so, flight, what has flights are for 10th of October. Reservation is until 10th of October. Yes, yes. Or okay, leave the hotel on 7th of October. Yes, yes. So you leave the room on 7th of October. Okay. I communicate with the agency. Yes, yes. I need the module, exactly, I need the form and the invoice and that's it. And you give it to me. Okay, perfect.
Non c'è il quarto dell'Accademia. Ma lo diciamo, il quarto dell'Accademia italiana. Italian style. Vado direttamente si guarda direttamente perché la presentazione abbiamo fatto stamattina, tutti i relatori, bisogna fare una produzione del compenso. 10 minuti. Okay, sorry for this short delay. Good afternoon. I'm very honored to be here, and thanks to my colleagues Michele Corleto and Professor Giuseppe Catalli, who decided to invite me for this very interesting and stimulating experience of the Master in European Competition Law. So I have a presentation, and just a few minutes. Is this one? Yes, thanks. We are used to start our lessons in Italy at the academy with almost 10 or 15 minutes delay. But you know, I'm sorry, this is a professional date, so you know, hope that you can enjoy my presentation, which you know, it's a little bit critical about the insert of competition as a legally protected value. Anyway, you are, sorry? Does not work? Okay. Works?
Yeah.
Okay. Sorry. Anyway, before to start, I would say that you can feel free to raise up your hand and ask for a question anyway, anytime, okay? For, you know, wherever you like to go deeper, I will be very happy to answer to your question, okay? So, okay. Quindi, okay. So this is my my first topic. When we talk about competition, it is interesting to me give you some theoretical inquiries and theoretical insights. Even as a judge, probably you like to have some explanation about how and when competition became a legally protected value, a legally protected interest. And we should go, you know, back to the roots of this principle. And we can, without to go too back, you know, for now, we can find this principle in very, very clearly declared in a statement of President of the United States, Woodrow Wilson, and in his 14 points speech. You remember he was in front of the Congress of the United States, and this is a very interesting speech because it was a kind of general statement in 14 points of the future of the world just after the First World War. And so he said in that context, one of the points, number 3, the removal, so far as possible, of all economic barriers and establishment of an equality of trade conditions among all the nations. So when President Wilson went to the Congress and spoke about the future of international relations, he was paying very much attention even to international economic relations. And he said, we can imagine a future with no trade barriers, you know, where the freedom of movement of flows and of capitals should be free. And it is important to me to underline that he was also stating for absolute freedom of navigation. We were at the beginning of the 20th century. There was no railways too much, no internet, no connection among countries. So the most important channel of communication it was still navigation. So he declared that it was important to realize the target of economic freedom and the liberty of movement, to leave free the navigation channels. And I will explain the importance of this with the next slides, because you know, freedom of movement, freedom of trade, needs of communication channels. So at that time it was navigation channels, and then they moved to other channels, but the principle is the same. So what is freedom of trade at that time? If we look at the interesting decision of the Permanent Court of Justice in 1934, it was Britain against Belgium, there is a principle of freedom of trade explained. So the Permanent Court of Justice, the Permanent International Court of Justice said that freedom of trade consists in the right, in principle unrestricted, to engage in any commercial activity. So we have in 1934 a kind of statement of what freedom of trade is: to freely engage in any commercial activity. And they had, in the same statement, at the same paragraph, paragraph 82 of the Oscar Chin case, this freedom to engage freely in any commercial activity means included purchase and sale of goods, or industry, or particular transport business. So the Permanent Court of Justice was very clear to give a legal definition of what we mean about the freedom of trade. And when you say this principle, when you watch out to the meaning of the principle, this has the same meaning inside the country or outside the country, okay? So in order to facilitate import-export, this is the definition of Permanent Court of Justice in the Oscar Chin cases. So now we look very closely to the principle of competition, because in the same statement, the court said, freedom of trade does not mean the abolition of commercial competition, but it is a kind of pre-requiring of the freedom of trade. So if we say, if we don't, you know, make flat the level playing of fields of an enterprise, we cannot have a free access to the market, we cannot have, you know, freedom of competition. So before to gain a real competition against enterprises, against subjects in the market, we should level the playing field as flat, so give them freedom of access. So it is it presupposes, you know, the existence of such competition. So when we look at the freedom of navigation, the freedom of navigation is so important, and they say, no, you know, this is the Permanent Court of Justice. It's not, you know, an academic scholar or so on, but they say freedom of navigation, it's so important that has a very concrete meaning. It's not only theoretical. It's the freedom to engage in a business, attention please, in order to reap its profits. So these elements are very important. You don't have only to guarantee the access to the market, but you should also give to the actors, economical actors, a chance to reap its profit, to create the conditions in which they can reap their profits. Okay? So this is why we say that the freedom of commerce is a kind of structural principle of international economic law. So it's a kind of basis of, you know, the construction that you can have with the rules, the secondary rules, and so on and so on. But this is a kind of principle or structure of the international economic law. So international law is really intertwined with the international economic law, because at this basis there is the economic worries of the interstate relation to better development their relationship, and then to create a condition of freedom of commerce. Anybody had the chance to read the writings of Mr. Carl Schmitt? He was really underlining these aspects of how international law was born, in the recent times, and the reasons of the modern international law are very well connected with these economical worries. Okay? So, trying to summing up, we can say that liberty of commerce, freedom of trade are always the same, has at least two main corollaries. The first is the freedom of economic initiative, and the second is freedom of access to the market. And then we saw that it's kind of a prerequisite of the competition, strictly called, okay? So looking closer to freedom of economic initiative, we can say that it's not only the freedom to promote or not industrial, commercial, financial activities, but also freedom of access. So freedom to enter in a certain field of business and to compete with other actors, okay? So this is the freedom of economic initiative. This is an Italian author, Mr. Natalino Irti, which wrote an interesting book about the legal order of the markets, okay? From this statement, you can have another statement, which is the connection from the historical side and the logical side, still pertaining to the two apparently different notions of freedom of economic initiatives and competition. So now you can look to these two definitions as very close to one another. It's like two sides of a medal, okay? That's very interesting to me. Start looking back to what happened in the 17th century. It was starting the period of the Renaissance and the development of closer economical connections among states. We can find many statements and bilateral and multilateral agreements of powers advocating the free of trade and the free navigation and terrestrial passages for what we now call the rising up of the merchants, even of the Lex Mercatoria, which was supposed to have a floor of equality, even stemming from these bilateral and multilateral agreements. So, and Matti Koskenniemi, one of the most important international lawyers in the world, studied very much this period of the history in order to, better understand the rising up of this new class of merchants. And he wrote an interesting article, International Law and the Emergence of Mercantile Capitalism, from Grotius to Smith, in 2014. And he noted that, there were these powers in the 17th centuries, they were, very happy and very excited and stimulating when they have to declare in the bilateral and multilateral agreements the statement on the paper of free trade and free passages. But after this, no competition at all. They had the power to establish a kind of monopoly. So the principles were useful to reach a different target, not on the paper but on field. And this target was according to Mr. Matti Koskeniemi, a kind of monopoly. So it's a kind of, heterogenesis of the ends. You are declaring something and you give to this even legal protection that you can go to the judge in order to protect your interests, but then if you have the power to do it, under the cover, you are trying to establish monopoly for your personal interests. That is very interesting. So Matti Koskeniemi wrote, trade served statehood, and statehood served the interests of private traders. And this is very important to me, for you even to understand as judge, because this double face of international law is still now in force. What does it mean? That international law is constructed to have a kind of, double morality. So probably we have interesting for human rights inside and so on. But when you are talking about international relation, every state is looking for its own interest, and it tried to build a kind of basket of rules that serves the interests of the companies of its own states. And if you look to what is happening in many states, for example, when they have to win some procurement abroad, it's a kind of state affair, state business, and you move, Secret Service, you move a lot of professionals. So there is a kind of merge of interest among companies, private actors, and the states. This is not, only a current business. This kind of business, this kind of understanding international relation, in my view, and not in my view, but also of most, writers more famous than me, it takes the roots in the past. It's the same construction that we also found in the 17th century. This is very important, even for our next presentation on Sunday morning. For those of you who are not going to sleep too much, at 9 o'clock, we will be here again talking about corruption. And this is the same. If you look at the phenomena of international corruption, many times the funds are coming directly from the state. So there's public funds, apparently for the reason of states to win a procurement, to win the license to exploit petrols, license, and so on and so on. Okay, I cannot give you too much details, but don't sleep on Sunday and we talk about this. Okay. So, summing up, according to Mr. Koskeniemi, freedom to enter in a market and to compete with they were the very engine on which Europe's ascent to the world dominance was based. So, the ingredients of this ascent to the world dominance were freedom of access and freedom to enter in a market. Because if you declare in advance this logical, which then you are, consolidating in a legal principle, then you are facilitated, for your aims of power. So, and then let me give you a flower of a different kind of orders. If you look at Italian constitutions, many of you probably at least once you read it, there is another kind of approach to economic freedom, because if you look at the first sentence, the general principle is the same. Okay? So private economic enterprises shall be free. So the general rule is the same. But the second one gives you the derogations to the principle, which are not derogation, but the limits in which you can exercise this freedom of private initiatives. And these limits are very interesting because they are so well specified that you can have a kind of track, and you cannot go out of this track on the left or out, on the right. You have to stay in the track, because our constitutions gives you. And you can also see a kind of torsion, and then we'll watch this principle better about competition and this kind of meaning of private economic enterprise. Because this kind of freedom of a private economic enterprise must be interpreted according to the light of which one? Social purposes. So it's a kind of, upside down of the principle. No competition if not biased to the social purposes. Okay? So let's look now to the international law, domestic law, now European law, which is almost, the main part of my presentation. So we said that you can find the freedom of commerce as a structure of international law. What's going on with European law? So probably is something similar to international law. Probably is something different. Let's see. We can observe a kind of move, a progressive move, to the liberalism, even in international law, to the embedded economic liberalism. What does embedded liberalism means? Does anybody of you have here about this principle of embedded liberalism? Okay, I can explain what I mean. Embedded liberalism is different from liberalism at all. It's a concept of a control of the social and legal and economical structure whose aim is totally biased to reach the freedom of commerce and then the competition. Okay? So you have to lie the layers of the authorities from the lower to the highest are totally biased towards one scope, which is to give the maximum of legal and economical guarantees to the liberal principle of the economy. So it's a kind of contradiction, because it's not the Adam Smith, step back of the administrative state which leaves the markets free to self-regulating. It's not this. It's an administrative state which is totally biased towards the control that everything is going in the direction of the playing field we supposed to have, in order to reach the maximum of free of markets. Okay, it is clear. So I give you some practical example of this embedded liberalism. For example, money and trade. There must be control about, the money exchange and the values of money, control about the currency, control about the commodity, and so on. So all the structure of the states are aimed to this kind of control. So if you look at the European economic order, you can find that it's very closer to the theories of the Freiburg school of the Ordo liberalism, which has only one experience in Germany for a very short time after during the Weimar Republic. Okay. So the constitutional principle of the social order, you know, are almost the same of the economic sphere. So there is no too much difference among them. And this means that, you know, competition law, you know, it rises up to the rank of a constitutional principle. This is very clear stated, you know, in the European Union treaties, and I will give you some example of this, okay? But it is important to me that you can understand with this presentation the theoretical framework of this construction. So we are traveling a little bit in a higher floor of the floor of the treaties and the primary and the secondary rules. We are flying, you know, looking at the principles, which are the roots, in a way, of this kind of construction that we are going to find in the treaties in a few minutes. But it is important to me that you can understand the principles that are the background of this kind of constructions, or legal constructions of the treaties. Okay? Any question about this? I'm going to sleep, to sleep. I'm going to sleep, yes, because after lunch, a small nap, it will be good. Okay. So, I can sleep a few minutes if you don't have a question. Okay. So, is it clear? Okay. What is the basic bargain? This is Mr. Robert Reich. He is not a lawyer, he's an economist, but it's interesting because he found this slogan. So how the member states of the European Union applied in the reality, in the concrete meanings, these theoretical inquiries of embedded liberalism. So states, there was a kind of even Karl Polanyi wrote about the double movement, you know, but this is another story. He was almost an anthropologist, so we cannot go too much too deeper in this, but it will be interesting. Anyway, as I told you, they said, okay, we don't care too much of this development of international relations and of the structure, legal structure of international relations, which means the model of international organization created after the Second World War, which, you know, answered to the logic of the so-called Washington Consensus, the World Bank, the International Monetary Fund, and the institution that has been created in order to fully answer to that kind of logic, you know? And then even the European Union, which kind of logic? Embedded liberalism. So liberalism according to this principle of control, you know, about the targets, about the principle, and so on and so on. So the basic bargain was, we don't care too much about this. And, you know, the United States had a lot of power, you know, to give their fingerprint to this kind of economical bias. But we care about how the profits and the profits that we get from the economical growth thanks to this kind of relations, or international economic relations, how the profits are expanded in the domestic jurisdiction, which means to make the welfare system stronger and stronger. So to have a kind of distribution of the profits in order to develop better develop the condition, the economical conditions of the working class, the middle class, and so on and so on. So, stronger trade unions and a stimulation to economy according to the model of Keynes into the domestic walls, and Smith abroad. So the basic bargain work in this case, which the model of free trade abroad and domestic jurisdiction on welfare systems, okay? So it's a kind of, let's say, division of labors. So I don't pay attention too much to the international economic law, but I care a lot about national welfare system. So this is a combination of Keynes and Smith, okay? Because Keynes cared about how the state is spending money, and he was really interested into the welfare state of the working class, because they say that even from the extent, you know, of the working class, which is always, you know, a majority of the population, if you give more money to the working class, this money immediately go into the circle of economy, and all the country from economic view can get, you know, profits about this. So this is the slogan is Keynes at home and Smith abroad. Okay? So Mr. Keynes is on the right side. He is a very interesting person, even if you want to study. There are a lot of biographies about him. He was 2 meters tall. He maintained 2 families. Yes, but one with a man and another one with a wife. In a time in which in the UK to be homosexual was strictly forbidden. He reached to take the food in 2 baskets. Anyway, this is not, you know, this is interesting because he was a genius in this field. But he was even able to understand in advance the rise and fall of the economies. So he invested a lot of money understanding the process of the economy, but as almost sometimes happens to the genius, he was too early in this investment, and so he lost all the money he got in a short time. So he was poor at the end of the day. Anyway, this model. So this is my only picture because, you know, as you probably understood, I love Keynes not as man but as a scholar, and I'm very interested in these thoughts. So this model probably, no, 100%, not probably, is now in crisis. The crisis of the model has many causes and many worst effects. For example, one of the causes, Mr. John Weiler of the NYU wrote in the 80s a paper, very interesting, and talking about the dual character, legal and political, of supranationalism. He was focusing on the dynamics of the European Union, and he was interested because he noted, even in the 80s, that domestic legal systems and domestic administrative system, they were not too much worrying of the European plane, what is going on with the European Court of Justice, with the European institution, because they were free, this institution were free to move towards this model of embedded liberalism with no obstacles at all. The politicians, they were aware of the fact that for the main process in the European Union, they need of unanimity. So they say, okay, if something really big is going to happen, we anytime have the power to stop it, because even just one actor in the circle can say, okay, no more, please. So the process is stopped. But if not, for many, many, many years, the process of the establishment of the creation of the four main freedom, liberty of movement of goods, of persons, of services, and capitals, it was left alone to the care of European judges and European institutions. And when, you know, there were some kind of tensions among the system, the politicians were too weak to, you know, react. And it seems that the street, you know, was, you know, step by step going on. So this is Mr. John Weiler and NYU. From this process, there was a turning point, of course, after the huge economical crisis of 2007. This model cannot be functioning too much as before. But now we are closer to the primary rules. This is a kind of hazard to create a parallelism from Article 3 of the Treaty of the European Union. Sorry, this is two ways Italian, I forgot to change, is TEU, Treaty on the European Union, and Article 3 of the Italian Constitution. So if you look at the Article 3, which we are still in the main principle, you can read that the meaning of sustainable development is based on balanced economic growth, this is important, price stability, you know, the war against inflations, and bold, highly competitive social market economy. So this is in the principle of the European. Okay, nobody knows what highly competitive social market economy means. I tried many times to understand the meaning of this sentence, but probably you can help me. I could not understand what does it mean. There is no economic, social, market, economy model. I don't know. So it's a kind of attempt to take together something that you cannot take together. So highly competitive market economy plus social. So it's a black and white together. And if you look at the Article 3 of our Constitution, you can see the tension with this model, with our principles. Because
Vediamo che è molto diverso, dato che la qualità è soltanto su carta e dal punto di vista della Costituzione il compito del legislatore e delle agenzie amministrative è di raggiungere l'uguaglianza reale per arrivare alla soglia della dignità, del sviluppo sociale.
No competition, but try to really reach the freedom of access. We say the equal opportunity, but not from you know, a kind of legal fiction that we are all on the same foot at the moment of the start. You know, when there is the bang. No, we are not. So the task of the administrative bodies is to, at the moment of the bang, to level the playing field in this meaning, not for competition, but in this different meaning, okay? So look at the Article 119, which opens the Title 8, if I remember, Title 8 of the Treaty on the Functioning of the European Union about economic and monetary policy. And if you look to the article which opens the Title 8, you can watch something different. You can read something different, because it said that these purposes of Article 3, they are requiring, of course, a closer coordination among member states' economic policies, but also they must be conducted in accordance with the principle of an open market economy with free competition. This is the first comma. The second said, again, it repeats again the same. This activity, must be conducted in accordance with the principle of an open market economy with the free competition. So, where is social? Social disappeared. We say sometimes the devil is in the details. So you started with a call to social market economy, but when you are closer focused on the economic and monetary policy of Article 119, social disappeared. And we could see the effects of this in some interesting decisions. I don't want to go deeper because they are very well known, even for those of you who are not interested too much in the labor rights. But probably you heard about something about the Viking, Laval, and Ruffert cases. And they were interesting. We are talking about the balancing of economic freedoms and fundamental rights. And for example, the right of strike, which is in a provision of our Constitution in the first title in the fundamental rights. And they said, the Luxembourg judges, they said, no, when the right of strike, it's interfering with a fundamental norm of the treaty, which is aimed to realize the freedom of services. Even the right of strike can be compressed because we have to remove obstacles to the realization of the free market. Okay? So this decision has been really criticized because the message that they were sending not only to the scholar but even to the trade unions that has been weakened by this judgment is that, you know, the fundamental economic freedoms are under, in a kind of logical and legal hierarchy, the fundamental rights, like the right to strike. Okay? Is it okay with this? Have you ever heard about this decision? Okay. So, after this we are reacting to the economic crisis in different ways. But it seems to me, and maybe you can help me to understand if I'm right or I'm wrong, it seems to me that all this kind of reaction, even if not aimed to strengthen the welfare system, are going against the model of strongest competition, highly competitive economy of the treaties. Okay? I mean, what we are reading every day on the newspaper about the rising of protectionism. United States started, but, you know, a kind of reaction from China, even from Europe, and so on and so on. So, new trade measures. The reaction to the economic crisis was the insert into the legal system of thousands and thousands of non-tariff barriers, which on the material plane, they have the same effect of the trade barriers. They are non-trade barriers, but they are barriers. And the effect is the same, to discourage the trade among countries for administrative obstacles, license, and so on and so on. So technical standards, when the technical standards threshold is very high, it's very complicated. For example, in order to participate to procurement, you don't give a chance to firms coming from abroad to participate to procurement, for example, because the technical threshold to apply is too complicated. Too many requirements. Okay? And also subsidies. Subsidies, as for the competition markets, subsidies are the devil. Because when you are going to give money to a company which is not able to walk on its own legs, you are undermining the free competition about companies. And so, if you look at American Journal of International Law, there is a very interesting editorial comment in 2018, last year, and the title of this editorial comment is "The End of Multilateralism Life Cycle." So this is very interesting, even for what we told before about the construction of the institutions of the so-called Washington Consensus, IMF, World Bank, and so WTO, of course. So this editorial comment said, multilateral institutions as a life more or less as well as human beings. They born, they are going up, and there is also die. Are we going to the die of these institutions? And there are many examples about this huge crisis able even to destroy the system built after the Second World War. One of the most important is the WTO, which is now in a deep crisis for a lot of reasons. I don't know if some of you is interested into this kind of stuff, but there is the appellate body, and it cannot work, or at least it works 60%, because the states are not interested into the new nomination of judges that are retired. So it's a kind of deliberate target to slowly go to the stop of the body, to stopping the body, because they are refusing to give the names of the new judges. And the same is for the organization of the whole organization. So the WTO, they are trying to leave the WTO like an empty box because they are overcoming the rules of the WTO. How? Closing thousands of bilateral agreements, you know, that are some like lex specialis. So nobody actually is still interested into WTO. They are trying to bilateralizing and the trades with the special treaties among small number of countries. So the WTO is in a very huge crisis. Any question about this? And even if you look at the ICC, International Criminal Court, there are many problems even at the kind of environment because some states that has been treated to have some kind of suit against them, they decided to withdraw from the ICC. Okay? So I do not agree with your decision, and I go out of the club. Okay? I don't want to be a member of this club anymore because I don't like you, because you are treating me. So, this is American Journal of International Law 2018, the end of multilateralism life cycle. But the conclusion of this article is not so negative, because when you say that the institution has a life, you are probably also saying that after this, you know, you can find another way, a new way to build a new multilateral economic relations, probably fitting more with the new exigencies that are not the same of 70 years ago. Okay? So, summing up, the institutions are not fitting anymore for the new exigencies. And if you are not able to refunctionalize them for your own purposes, you go out. What is happening in this framework to the welfare? The situation is complicated. I'd like to show you a kind of new technique of balancing different competing values and interests. And this could be interesting for you. After, you know, the Viking, Laval, and Ruffert, we also had a different example of cases decided by the European Court of Justice. Have you ever heard about Omega and Schmidt-Berger? Very famous cases. Probably you know. So, the European Court of Justice started to think in a different way to these two competing, let's say, legally protected values: competition and fundamental right. We can say fundamental freedoms, the four freedoms, and fundamental rights. And in these two cases, the European Court of Justice decided to start a new model of reasoning, which is trying to balance the importance of the fundamental freedoms and fundamental rights. And in this case, even if not clearly stating that there is a hierarchy among them, prevailed the fundamental rights over fundamental freedoms. Okay? So this was the first time in which the market of freedom found some kind of stop from inside, so from the European Court of Justice. Because there was a tension among these competing values of fundamental freedoms and fundamental rights. And for the first time, they say, okay, in these cases, we must create the condition for fundamental rights not to be pushed and compressed by fundamental freedoms, because we are a state of right, and there is a charter, and so on, the Charter of Fundamental Rights. Okay. So, is it clear, this scheme? Is this clear, my presentation? Okay. So, let's go to another kind of competition. So the competition among indebted states. So the states with the huge public debts. So they are on the market as actors trying to catch money. And this is also a competition. And this competition has a lot of reflexes on the daily life of people. Because they are finding techniques to attract capitals, which probably has a small, let's say, side effect to lower the standards of many public services. And when I wrote here, welfare perceived as a competitive disadvantage. So the welfare is not advantage for people, for the sake of the indebted state, which is on the market among other competitors, the welfare is a disadvantage. It's okay? Yes, please. Mike, please. Okay, yes. Yes, sure.
I'm not sure I understand it fully.
Yeah, I will explain you better.
I have, it's about also the Article 3 says something social, market.
No.
It's stated over there, no? Just want to make a comment.
Of course.
What's about competition? Competition law. In the end, what is the purpose of the competition law? In the end, it's restrained. You see Article 101 and 102.
Yes.
In the end, they restrict the freedom of the enterprises, which means that enterprises are not freely to move wherever they like in the market. This is the restraint of their freedom. In the end, competition law regulates somehow this freedom of trade. And it's the job of the member states to ensure that whatever one can to ensure the freedom of trade, and the other way to find means to protect is now need the social, to ensure that the welfare gain as the competitive process is distributed fairly among the participants in the market, consumers on the other hand, and the takers. So this social, this perspective of the social, this tries to encompass a fairness of the trade in the end, results also to the consumers, and also to ensure that the undertaking has enough more room to maneuver. But 101 and 102 in the end, they are restriction to the freedom. There's a restriction, and also the national law should follow this, and you follow this approach. Because it's a restriction, but this restriction is regard also, it's from the perspective of the welfare, the distribution of the welfare.
Yes.
You know, it's a small comment.
No, it's okay, but I take your point, but it's the same. It's just the point that I was trying to explain. That we are, sorry. It's okay. Thank you very much for your comment. You know, the problem is the short circuit that you have when you have the crisis, economical crisis, and you are not able anymore to care too much about the welfare state inside, but on the same time, you are switching the role of the state from not taking care too much about international relations, but to create the level playing field from inside. But you are indebted and you are constrained to make money for this debt, for the European rules and so on. And so you are looking for the competition as with other states. So you are in a market with other states. So you...
Ireland, the case when the Commission says that Ireland should collect the taxes from Microsoft.
For example, yes, I was going toward this direction. It's okay. No, you're okay. You are in advance with the tasks. Okay, you did your homework a little bit earlier. Okay, I'm joking. Thank you very much. And so this is interesting. For example, the erosion of the basis of this competition. So I have to take money from everywhere I have. The fiscal competition, it is supposed to have some side effect negative for population. So if I have to be competitive with other states, there is a kind of attraction of multinational enterprises, but who is going to pay the prices of this? Okay? And we are on the topic. Because competition is always competition, and this case is not competition among enterprises, but it's competition among states. And we have two sides of the same coins. From one side, we have the private contributors, and they pay a lot of money to account in order to get the best planification of their aggressive tax policies. Okay? And the other side, we have a kind of the same model because the states has been pushed to the so-called harmful tax competition, HTC. So, harmful because it creates damages. So it's not healthy tax competition. And this is the link with the comparative disadvantages of welfare state. Because if I'm the CEO of a multinational enterprise, I can choose to go to delocalize my activities where the welfare state's services and the wage of the workers are lower, because this difference, yes, and as much as they are lower, as much is my gain. The more is low the wage, the more is higher my profit. So when the states became part of this competition, welfare states, it's a comparative disadvantage. I mean, is it clear now? It's,
clear.
Yeah. Yes. Yeah, sure. Yeah, sure. So, and we have the stateless income. So, what is the phenomenon of stateless income tax planning? Probably you have heard about this. I'm not, an international tax lawyer, but in a very few words, you can imagine the dissociation, of the country profits where the business activities are, where the domicile of the group is, and there is agreement, you know, from in a country that you have to pay where is your business activity, and the other one where is your domicile. So ping pong, tan 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 tan, nobody pays. And this is legal. This is legal. You can also take a picture of this if you like. I can give you the permission. This is legal. So you are a judge, and you are, you know, with the hand, yes, sorry. Nobody knows how can fight against this kind of phenomenon. Nobody knows. And this is one example. Double Irish Dutch sandwich. So Google did it. And we are talking about several billion of dollars. Okay? So the solutions must be found in the international arena. If we are going deeper with this phenomenon of tax competition, we cannot, no states can solve it, you know, by itself. There is a needing of international cooperation for this. But the problem is that nobody wants to do, because if they already have this kind of agreement, they cannot. If they don't have, they are pushing them, but you know, they cannot manage it by themselves. So the problem is also linked to the crisis of multilateral institutions, because in the past they could push states to find a solution, but now they are weak. Okay? So this is a very interesting field, but it's very hard to find a solution. Another problem is the competition to attract FDI, which is foreign direct investment. I don't know if you heard about the Veolia case against Egypt. It's very interesting. Does anybody heard about this? The case was introduced by the Veolia, French multinational enterprise, against Egypt after the Arab Spring in 2011. So Egypt was in a very difficult moment. There were thousands of people in the streets protesting about economical conditions. There was a huge inflation. There was violent turmoils. And so, for political reasons, Egypt decided from one day to another to make the wage, the average wage, the average wage of the workers higher than before, okay? From a day to another. It was a decision pushed by the population in the streets and the turmoils and so on. So it was an act of states in a way, okay? So Veolia was the enterprise who won in Alessandria the cleaning services for the city. And they started to have some kind of discussions with the local government, because they say that they were stealing the container, or the garbage many times. So they said, you are not patrolling the streets, and we are losing a lot of money because of this kind of continuous replacement of this kind of boxes for the garbage. Okay? When the government decided to approve the new law about the higher wage, they went to the arbitrators of ICSD, the system that you know for the control of judicial control of controversy among states and private enterprises for investments. And they say, you know, I feel that this is wrong and I have legal points because my business plan, it was done, you know, with the other lower wage. So with this new wage, I am going to lose my money. And so you have to pay for the difference, because I am not able to do my service with this new higher costs. So for your law, I'm losing my profits, and you have to compensate me for 174 million of euros. So this arbitration went on for 6 years, and nobody knows how is this ended. Because I have here the only document we have about this arbitration is a press communication of the last year, which says that Veolia lost its cases against the government of Egypt. The decision is still secret. Nobody knows what they said, what they decided. So there is something wrong with this, because probably, do you know Pirro, the general in Apulia, which was losing many of soldiers, but somebody went to him against the Roman, and they said, oh, we won the battle. And Pirro said, another battle like this, and we will die, because we won, but with 1,000 of soldiers died in the field. So probably Egypt didn't want to release the reasons of this, let's say, victory, because probably he had to pay a lot of money. And Veolia accepted to keep the secret because it was not interested into the publicity. Even for Veolia could be a negative advertising if the government said, I lose the arbitration. So probably Veolia said, okay, I accepted that you say that Veolia is losing, but give me money for this, okay? So absolute lack of transparency. And we are talking about the reason of states. So the reason of states against the reason of a multilateral enterprise. I don't know who is the winner, really the winner. Because even if this is, you know, the worst, but even if it is the best that Egypt had not to pay too much for this. Anyway, they had to pay the lawyers. And you know how much they are paid for this kind of arbitration. So there is a kind of retirement of the legal jurisdiction. The legal jurisdiction has been overcome by the arbitration. And there are a lot of simulation to go to the arbitrators, because they say, you don't have to pay me now. You pay me only when the decision has been issued. So the legal officers in New York or in Paris and so on are so economically strong, like the multinational enterprises, that they can work even for free until the end of the arbitration. So not like the state that have to pay in advance. Okay? So, we are talking about competition, and then we move to talk about the weakened sovereignty. In my view, I found this an interesting sentence of Judge Benjamin Cardoso in 1921, and he said there is a tendency of each principle to expand itself to the limit of its logic. To me, we reached this limit. So, thank you very much for your attention. Any question? Okay, we will meet again on Sunday. Okay? Thank you.
goods on the retail market, and I sold this input to the competitor in the retail market. The problem is, as a fishing competitor, if with the price which I sold this input to the competitors, I'm still able to compete with the market. If the prices I charge my competitors, if I charge my own arm, my own division, will make the profit high. So this is not it is as much as classic. The example in terms of telecom is also the telecom cases. Most of them are in the much space. With Deutsche Telekom, which is Telefonica, so on and so forth. So you have to check this exactly. But one thing he says is very interesting about state aid. He left the problem is more or less solved. But the problem is the state may have to intervene in the market. What is state aid in the end? State aid in the end are subsidies given by the state to a national operator in order to make it to assure. It's very important. There are some rules. And exactly because the commission is a monopoly regarding the state aid. Right now, the member states are just, let's say, somehow overseeing and let's say, support. Yeah, contact points. But the problem is that
Si vede dentro, così è la luce, vero? Scusa.
Sì.
Attendo un attimo che entrano tutti, prima di darle la parola distribuisco un attimo gli evaluation form perché altrimenti finisce che...
Sì, poi alla fine c'è la fuga.
Esatto.
Questo che sta facendo un aggiornamento, allora non lo tocco, perché io dovrei mettere la pendrive, però aspettiamo
Le
che...
mando la versione
Vabbè.
che sta gestendo il forum.
Madonna, fantastico. Le cose inaspettate ti cadono proprio. Devi chiamare il tecnico per cortesia. No, quell'altro, quel tecnico con la camicia bianca, che scemo qua stamattina. Ah, Fede, stai spostando? Io per forza. Madonna, ti rendi conto? No. Che ciorta, che ciorta.
Che ciocca? Che batteria scarica?
Senti, qua questo è lo stesso HP, guarda. No, vai. Madonna. L'ha inviato oggi a te Savarese, tu non hai risposto.
Cosa?
Poi. Ecco.
Io non la posso capire.
Ma perché non la metti su
Si può che non la riuscivo a configurare, io da sempre che non ce l'ho più. Perciò le dico sempre con un medicale.
Ma perché non la vedi su
non me la fece inserire perché c'era il
No, non
problema
fatto. C'è il problema?
della conferma del codice che non mi arrivava. Allora provai la mattina dal computer di casa, poi alla fine finalmente riuscimmo a risalire questo codice di conferma che deve arrivare a lei e la confermai da casa e non me la faceva fare anche dal cellulare. Quindi no, ormai non sono mai riuscita a inserire. Ma sì. No, solo sapere.
Mettilo là.
Vediamo il mouse.
Così ho detto su
Ma dagli un attimo, ti prego, che deve avere ancora la linea. Fallo poi carica bene.
Va bene. Vedi se questo funziona. Morto.
Ancora è collegato.
Vado?
Sì, vai. Grazie.
L'altro ragazzo deve andare. Che fa?
Montaggio.
Abbiamo rapidamente cambiato computer per sicurezza. Se ce l'hai non dai, eccolo qui. Ce lo facciamo subito.
Sarei stremato, fino a lui.
Un progetto molto sì, abbiamo ovvio. Scusami, Roberta, mi dico scusami.
Non legge la pendrive.
Non legge la pendrive e non va su internet.
No, no, va.
Non legge la pendrive.
Cioè, in realtà ho fatto un'accensione, ma... La sta leggendo. Te l'ha letto. Vediamola prima che sia troppo.
Naturalmente, questo l'ha fatto lei, però non abbiamo scritto sopra, abbiamo deciso quale ottimo e quale penso sia chiaro, no? Che lo dobbiamo spiegare perché uno ha chiesto, vabbè dopo facciamo un riepilogo. Ok.
Ma non so perché noi siamo un bel po' ci hanno messo, non so poi alla fine, bisogna vedere, io non c'è questo di turnazione, io l'ho fatto 3 anni fa, però non per evitare, no? Sono lungo più che altro perché puoi fare un orario di pensare, correggi gli schemi pure, sono sempre numeri. Questo è tipo Valentino che dice non leggiamo di questa cosa, io non si deve fare, perché non leggiamo né per la Commissione europea, certo sì, su cosa? Sì, no, questo no, questo ho fatto qualcosa su... perché mi sono messo il nome dell'università vincitrice e il coordinatore scientifico che era lì. Forse no, teniamolo come terza di riserva, però ecco, pronto la presentazione di oggi, il relatore puoi fare direttamente iniziare quando ritiro. Tu vuoi andare avanti col mouse come lo preferisci? Ti dico però al centro, lasciamo quello? Sì, sì, lasciamo questo, lo mettiamo qua, questo come riserva se succede qualche... Qualcosa tu? No, no, c'è bisogno, abbiamo già presentato. Siamo in diretta streaming.
Well, it's really an honor for me to speak today with my colleagues from the European Union because I am a civil judge in the town of Napoli, and it's an honor to speak in this beautiful building. My contents are, I think, boring. Because we introduce ourselves in the terrific technicalities of competition law, but for me today the task is to simply introduce the content and scope of these two fundamental articles, 101, 102 of the treaty. So we have in this matter some foundational principles. The overall legal system of the Union, we know, is based on the values underlying the free markets economy. The main purpose is to protect a workable competition, and the competition rules contribute to the creation of an European unique market. We all know that the Court of Justice stress continuously that national judges are integral part of the system. We are the arm of the Court of Justice, so this contribution to the creation of the market is mainly in our hands, I think. The legal framework, in general terms, is given by, first of all, Article 3 of the Treaty of the European Union, according to which, among the exclusive competencies of the Union, there is the definition of competition rules. In the second place, we have to stress Protocol number 26, according to which the internal market, as set out in Article 3, includes a system ensuring that competition is not distorted. To this end, the Union shall, if necessary, take action under the provision of the treaty, including Article 352, the so-called, clause of flexibility. Articles 101 to 109 of the treaty set forth the fundamental rules and also principles in this matter. We have two kinds of rules. Rules for the undertakings, the strict competition rule of the system, Articles 101, 106, and rules for the member states with the difficult regulation of state aids. According to Article 103, the legal framework is continuously completed and implemented by the powers of the Council, which is empowered to adopt directives and regulations on the proposals of the Commission and with the Parliament's consultation. The Council, in turn, can delegate the Commission to adopt regulations. The enforcement of EU competition law is twofold, and this is very important. It's public and at the same time private. The public enforcement is realized mainly by the EU Commission and in an important measure by national authorities, national competitive authorities of each EU member state. The private enforcement is mainly realized by means through the private claims before us, before national courts. And naturally, because public and private enforcement, there should be a high degree of cooperation among the EU Commission, the national authorities, and the national courts under both public and private enforcement. Before reading the text of these two articles, we have to look at the common features of Articles 101, which concerns the cooperation, the anti-competitive cooperation, and Article 102, which concerns the abuse of dominant position. The common features are the following. Both regulate actions by private undertakings, which can distort the functioning of the free market. Both have general application, but with certain exceptions. Both have direct effects in each member state. Both impose obligations on states and concern private undertakings. I think that one of the most important notion to focus is the notion of undertaking, because the notion of undertaking for the purposes of the application of competition law could be radically different from the notion which we know in our legal systems. For example, the notion of undertaking is really different, profoundly different from the notion that the Italian law knows in commercial law. So the concept of an undertaking covers any entity engaged in an economic activity, regardless of its legal status and the way in which it is financed. The concept of an undertaking in the same context must be understood as designating an economic unit, even if in law that economic unit consists of several persons, natural or legal. So undertaking is a broad concept, a very broad concept, which consists of an economic offer of goods and services on the market, even if it stems from entities or persons which are not considered undertaking under national laws. The crucial factor for the purposes of these two provisions of the treaty is the autonomy of the undertaking, which does not depend on other entities in carrying on its activity. Autonomy and independence are of a factual and operative nature. They do not overlap necessarily with the notion of legal autonomy of each entity under national laws. For example, lawyers in Italy are not undertakings. So the question before the Court of Justice in 2002 was the following: are lawyers undertakings under competition law? The answer was in the affirmative, because members of the bar carry on an economic activity and are therefore undertakings. Very simply, members of the bar indeed offer for a fee services, and they bear the financial risks attaching to the performance of those activities. So the consequence is that when the bar adopts a regulation concerning partnerships between members of the bar and members of other professions, the bar of a member state is neither fulfilling a social function based on the principle of solidarity, unlike certain social security bodies, nor exercising powers which are typically those of a public authority. So it acts as the regulatory body of a profession, the practice of which constitutes an economic activity. And likewise, the court in 2013, in the case Orden dos Técnicos, give the answer around accountants. Are accountants undertakings? chartered accountants offer for remuneration accounting services consisting in particular of planning, organizing, and coordinating the accounts of entities, signing their financial statements and tax declarations. In addition, it is common ground that accountants assume as members of a liberal profession the financial risks related to the exercise of those activities. Since where there is an imbalance between outgoings and revenue, a chartered accountant is required to bear the deficit personally. So the consequence is that having regard to the manner in which their profession is regulated in Portugal, chartered accountants carry on an economic activity, are undertakings, and the complexity and technical nature of the services they provide, and the fact that the practice of their professional is regulated by law by the state, cannot alter that conclusion. And now we can examine the text of Article 101, the first paragraph, which says the following shall be prohibited as incompatible with the internal market. 3 categories: all agreements between undertakings, decisions by associations of undertakings, and concerted practices, which have 2 features. First of all, may affect trade between member states, and secondly, have as their object or effect the prevention, restriction, or distortion of competition within the internal market. So the notion of anti-competitive agreements is satisfied by 2 requirements: a plurality of companies which are independent of each other and act autonomously in the market. This is the well-known criterion of the economic unity, because if there is economic interdependence, Article 101 does not apply. And a concertation in their activities. So all kinds of conducts are covered to the extent that they aim to distort competition. This is an important decision by the Court of Justice of 14 December 2006, Confederazione Estaciones de Servicio. For the purposes of applying the rules on competition, the formal separation between 2 parties resulting from their separate legal personality is not conclusive. The decisive test being the unity of their conduct on the market. In certain circumstances, the relationship between a principal and his agent may be characterized by such economic unity. In that connection, agents can lose their character as independent traders only if they do not bear any of the risks resulting from the contracts negotiated on behalf of the principal. Conversely, where those intermediaries assume the financial and commercial risks linked to sales or the performance of contracts entered into with third parties, such intermediaries cannot be regarded as auxiliary organs forming an integral part of the principal's undertaking, so that a clause restricting competition between the principal and the agent, which they have entered into, may be an agreement between undertakings under Article 101. So the first category is agreements. An agreement is a common will naturally, to operate in the market in a specific way. It deals with the real exchange of wills between two or more undertakings, and the forms may be various. This is the same written or verbal agreement or an agreement by facta concludentia. The case is Sandoz concerning contractual relationship between producers and sellers. The second category is decisions of associations. Associations of undertakings is an organization of undertakings which operate into a certain market. The decision may include binding decisions, orders, resolutions, and also non-binding recommendations, for example. In the case already cited, Ordem dos Técnicos, the court says a regulation concerning the earning of training credits adopted by a professional association must be regarded as a decision of an association of undertakings within the meaning of article. The fact that a professional association, such as the OTOC, is legally required to put into place a system of compulsory training for its members cannot remove from the scope of the article the rules drawn up by that professional association. The fact that those rules do not have any direct effect on the economic activity of the members of that professional association does not affect the application of Article 101, where the infringement of which that professional association is accused concerns a market on which it itself carries on an economic activity. And the third category, concerted practices. Concerted practices include all the forms of coordination and willful cooperation, concertation, between undertakings which undermine competition. So it does not require, and this is the difference from the concept of agreement, a reciprocal will by the parties, or a plan. It's an objective concept, notion, because objective coordination is required, which can be reached through direct and also indirect contacts among undertakings as well. What is important is the effect, the influence on the conducts and the choices of other undertakings operating in the same market under examination. How can we show the existence of concerted practices? Evidence is a problem. First of all, we have to focus on similar and parallel actions and strategies which are a serious element of evidence. And evidence of concerted practices can rely on telephone conversations, exchange of documents, meetings between undertakings which operate in the market, throughout exchange of commercial and secret data, for example, reductions to be applied to fees for sellers. And the effects of these three categories, agreements, decisions, and practices, is twofold. The first requirement we have seen, which may affect trade. So the prejudice should be relevant, and in this matter, the EU Commission has elaborated the minimis criterion. So the duties for undertakings under this article apply only to the extent that trade restrictions among member states exceed a certain threshold. The evaluation of such requirement refers to mainly the position of the involved undertakings in the market. If the position is strong, it is likely to find an important prejudice. One should control, on the one hand, revenues on the basis of an evaluation in absolute terms, and on the other hand, the market shares. This is an evaluation in relative terms because it works by means of, by comparing the position of the involved undertakings with that of different actors in that market. The prejudice is potential. So for an agreement, decision, or practice to be capable of affecting trade between member states, it must be possible to foresee with a sufficient degree of probability on the basis of a set of objective factors of law or of fact that they may have an influence, direct or indirect, actual or potential, on the pattern of trade between member states in such a way to cause concern that they might hinder the attainment of a single market between member states. The probability concerns the fact that trade could develop in a different manner. So this is an important aspect, I think. Not that trade would be limited or reduced. The important and what makes the difference is simply the distortion of a market, this potentiality of distortion, this possibility of distortion. The court in the case Manfredi has also clarified that we can have an important effect on trade also when effects are produced in a single member state. The fact that an agreement, decision, or concerted practice relates only to the marketing of products in a single member state is not sufficient to exclude the possibility that trade between member states might be affected and an agreement, decision, or concerted practice extending over the whole of the territory of a member state has, by its very nature, the effect of reinforcing the partitioning of markets on a national basis, thereby holding up the economic interpenetration which the treaty is designed to bring about. The case is Manfredi of 13 July 2006. The second requirement concerning the effects is given by the phrase agreements, decisions, practices, which have as their object or effect the prevention, restriction, or distortion of a competition within the internal market. So if the object itself of the cooperation is to distort competition, we have a clear element of evidence as to distortion. But if one could not prove that the object is to distort, competition is the distortion of a competition, nonetheless the effects on competition in the relevant market should be appreciated in the specific circumstances of each case. And we have to look more deeply the prohibitions and the examples of effects prohibited by Article 101. First of all, these agreements, decisions, or practices are forbidden and have an effect on the trade because directly or indirectly fix purchase or selling prices or any other trading conditions. In the second place, limit or control production, markets, technical development or investment, share markets or sources of supply, apply dissimilar conditions to equivalent transactions with other trading parties, thereby placing them at a competitive disadvantage, and make the conclusion of contracts subject to acceptance by the other parties of supplementary obligations, which, by their nature or according to commercial usage, have no connection with the subject of such contracts. The legal consequences are clarified by the second paragraph, because any agreements or decisions prohibited pursuant to this article shall be automatically void. It's a case of absolute nullity, which may be declared ex officio by national judges also, naturally, and produces ex tunc effects. Anti-competitive agreements are absolutely void. And this implies that there is no effect whatsoever between the parties and towards third parties. This is a typical remedy of private law, which is applied by national courts and works with the public enforcement provided for by EU law, mainly in the hands of the EU Commission and national authorities. A very important provision is that written in paragraph 3, because this provision concerns the exemptions. So the agreement, decisions, or practices which are considered perfectly legal, and the provisions so be declared inapplicable in the case of agreement, decisions, practices which contributes to improving the production or distribution of goods, or to promoting technical or economic progress. But the condition is while allowing consumers a fair share of the resulting benefit, and, in any case, which does not impose on the undertakings concerned restrictions which are not indispensable to the attainment of these objectives, and second, B, afford such undertakings the possibility of eliminating competition in respect of a substantial part of the products in question. We have two main forms of cooperation under Article 101, horizontal cooperation and vertical cooperation. The classical form of forbidden horizontal cooperation are evidently cartels, any form of cooperation between two or more competitors aiming to directly limit competition by fixing prices, limiting output, sharing markets, customers, or sources of supply, or involving other cartel behavior such as bid rigging. This is the so-called hardcore infringements of Article 101, and they are always forbidden with rare exceptions. For example, the so-called cartels of crisis, which could be allowed in particular periods of general crisis in the worldwide economy. In this sector, we have an important secondary legal provisions, because we have two important regulations adopted by the Commission, the Regulation 1217 and 1218 of 2010, and the EC guidelines. The guidelines concern separately both the horizontal and the vertical forms of cooperation. For example, the horizontal guidelines contemplate a series of hypotheses, information exchange, agreements on research and development, production agreements, purchasing agreements, commercialization agreements, standardization agreements, and standard terms. And in the same way, for vertical cooperation, we have an important Commission regulation, 330 of 2010, and guidelines, the so-called vertical guidelines. The Commission, the European Commission, adopted an effects-based approach. So the Commission, but also national authorities and national judges, when called to do this kind of interpretation, have to assess whether vertical agreements have appreciable negative effects on competition in the relevant market. Some examples of vertical cooperation: distribution and purchasing agreements, agency agreements, and industrial supply contracts. Also in this sector, we have hardcore vertical restraints. We can think to imposition of resale prices on the buyer, fixed or minimum prices, bans on cross-border sales, they are usually forbidden. This is an important technicality. Vertical agreements are covered by block exemption, which is defined by the Commission regulation and the Commission guidelines, where the market shares of the relevant parties do not exceed 30% threshold. The negative effects can concern surely the final consumers, but not only final consumers. Negative effects may concern other competitors, other undertakings, and all the undertakings which have suffered damage by this type of conduct. And we will see later the recent case law of the Court of Justice which concern damage actions before national courts by undertakings which have damaged by vertical cooperation, so not only final consumers. And the abuse of dominant position, Article 102. Any abuse by one or more undertakings, this is the legal text of the article, of a dominant position within the internal market or in a substantial part of it, shall be prohibited as incompatible with the internal market insofar as it may affect trade between member states. The same wording of Article 101. Such abuse may in particular consist in directly or indirectly imposing unfair purchase or selling prices or other unfair trading conditions. For example, refusing to conclude contracts or to concede licenses. limiting B, production, markets, or technical development to the prejudice of consumers, applying dissimilar conditions to equivalent transactions, making the conclusion of contracts subject to acceptance by the other parties of supplementary obligation. Also in this case, we have the same wording of Article 101. So the factors to be assessed in order to say that we have an abuse of dominant position. First of all, dominant position. Dominant position is intrinsically neutral. Dominant position is not illegal or legal. Dominant position is natural in many markets, in many substantial parties of markets. The problem is the abuse. So we have a dominant position in relevant market with an abuse which causes a prejudice to intra-EU trade. The definition of dominant position is object of a perfectly settled case law of the Court of Justice. For example, in this case, Telia Sonera, on 17 January 2011, the court says the dominant position under Article 102 relates to a position of economic strength enjoyed by an undertaking which enables it to prevent effective competition being maintained on the relevant market by affording it the power to behave to a relevant extent independently of its competitors, its customers, and ultimately of consumers. And the concept of abuse of this dominant position is an objective concept because it relates to the conduct of a dominant undertaking which has the effect of hindering the maintenance of the degree of competition still existing in the market or the growth of that competition. In order to determine whether the dominant undertaking has abused its position by the pricing practices, it is necessary to consider all the circumstances and to investigate whether the practice tends to remove or restrict the buyer's freedom, to choose its sources of supply, to bar competitors from access to the market, to apply dissimilar conditions to equivalent transactions with other trading parties, or to strengthen the dominant position by distorting competition. In the case, recent case, 27 April is Italian, April 2017, Akzo Nobel, the Court of Justice stressed, and this is an important aspect for this topic, the nature of the responsibility for violations, for breaches of competition law. It's a case, a form of personal responsibility. The term undertaking, we know, must be understood as designating an economic unit. When such an economic unit infringes the competition rules, it is for that entity, the author of the breach, according to the principle of personal responsibility, to answer for that infringement. The unlawful conduct of a subsidiary may be attributed to the parent company. It seems an exception to the notion of personal responsibility, because conduct of a subsidiary is attributed to another legal subject, another legal entity, the parent company, where, although having a separate legal personality, that subsidiary does not determine independently its own conduct on the market, but essentially carries out the instruction given to it by the parent company. So, if the parent company, this is the legal consequence, is part of that economic unit, one unit, it is regarded as personally, jointly, and severally liable with the other legal persons making up that unity for the infringement committed. We have a lot of secondary rules in this topic, in this sector of European law, but the power to regulate competition law by means of secondary rules is provided naturally by under Article 103 of the treaty, according to which the appropriate regulations or directives to give effect to the principles set out in Articles 101 and 102 shall be laid down by the Council on a proposal from the Commission and after consulting the European Parliament. These regulations or directives shall be designed in particular to ensure compliance with the prohibitions laid down in the articles analyzed by making provision for fines and periodic penalty payments, b, to lay down detailed rules for the exemptions provided for in the third paragraph, to define in the various branches of the economy the scope of the provisions, to define the respective functions of the Commission and of the Court of Justice, and the most important thing, I think, to determine the right relationship between national laws on the one hand and European Union laws contained in this section or adopted pursuant to this article. The main change in the system of enforcement of competition law is the fact that we have now decentralized enforcement. We have two fundamental regulations in this matter: Council Regulation 1/2003, which concerns the application of the provisions which we are analyzing, and Commission Regulation 773, which is the procedural regulation for the assessment of breaches of competition law. So the EU Commission had and has a central role. It has broad powers of control and decision, naturally, but since 2003, the system of both public and private enforcement is decentralized. So national authorities, the national authority of each member state, and national judges are empowered with important competencies in order to fully implement Articles 101 and 102, including the exemptions, subject to, and this is the overarching condition, ensuring that their rulings do not conflict with the decision taken or contemplated by the Commission. If the national competition authorities apply their national competition rules to cases involving trade between member states, the national authorities are obliged also to apply the EU competition rules. This is clearly stated by Article 3 of the Regulation number 1. So we have a procedure before the Commission which contemplates a preliminary step. The procedure can start on the following two bases. We can have an interested party, one member state, one person, one entity with a legitimate interest, which may claim against an agreement or a conduct under Articles 101, 102 by requesting the Commission's control. But we have the possibility that the power to start an investigation is exercised ex officio automatically by the European Commission. We have a formal phase which is formed, consists of a formal communication by the Commission to the parties of its findings with a time for observations, the possibility of observations by the interested parties, and we have important and far-reaching powers of investigation by the Commission. For example, request for information to the parties, interviews, inspection of both undertakings, but also of other premises. And the final step is the decision. We can have a finding which assesses the violation of competition law, because there is an anti-competitive agreement or conduct or an abuse of dominant position, with the indication on how to terminate the infringement. The Commission may impose any behavioral or structural remedy proportionate and necessary to bring it effectively to an end. The Commission, we all know, can impose fines, can adopt during this proceeding interim measures, can indicate to the parties commitments for the future, but it could also arrive to a finding of inapplicability of the two provisions of the treaty. It is to be stressed that Commission decisions may be appealed to the General Court of Luxembourg under Article 263 of the treaty, and in turn, the decisions of the General Court may be appealed but solely on points of law to the Court of Justice. So, the private enforcement of antitrust law, which is in the hands of national judges above all and national authorities. Since 2000, and it was the first step of decentralization, national authorities, each national authority can autonomously enforce EU competition rules in a parallel way, imposing fines, structural or behavioral remedies on companies which restrict, distort, or hinder competition. Since, and this is the very important change in the world of competition law in Europe, I think, since 2003, private individuals can claim damages resulting from the anti-competitive behavior of companies. This is codified by Article 7 of the Regulation 1. The Commission issued the Green Paper on damages sections for breach of the EC antitrust rules in 2005. But the real change, and all our member states are very busy in the application of this very difficult directive. Is the directive 26 November 2014 on certain rules governing actions for damages under national law for infringements of the competition law provisions both of the member states and of the European Union. Why is this directive so important? Because it has three main contents, three main purposes also. First of all, it would be facilitate the evidence in cases where evidence is the real problem. So it gives to us, to national judges, important powers to order the collection of information and documents by all the private undertakings involved in the anti-competition conduct. And secondly, the directive gives important indication as to the quantum, the quantification process of the damage. And finally, it puts an important principle which is also difficult for judges, or at least for Italian judges, because the directive says when the violation has been in a conclusive way assessed by the competition authority, both national or the EU, it is fundamentally res judicata, is conclusive and final for the judges, which have to assess two elements at this point. The causality, the nexus of causality between the infringement and the damage, and the quantification of the damage. So, actions for damages form an integral part of the system for enforcement and pursue the same purpose of punishing and deterring violations of the articles under examination. Deterrence, along with compensation, is considered one of the aims of the private enforcement, as well as with regard to its public enforcement. And these principles, before the directive of 2014, were already stated by the Court of Justice in these two cases, Courage and Manfredi judgments, where the court affirmed the right of individuals to claim damages before national courts arising from harm caused by a violation of EU competition law. National laws in this case are applied in accordance with the principle of equivalence and effectiveness. So we have three landmark judgments in this year by the Court of Justice which concern this directive and the various problems, issues which this directive and its application in the various EU member states are posing to national judges. The first case, Vanta, 14 March 2019, the court says, if the undertakings responsible for damage caused by an infringement of the EU competition rules could escape penalties by simply changing their identity through restructurings, sales, or other legal or organizational changes, the objective of suppressing conduct that infringes the competition rules and preventing its reoccurrence by means of deterrent penalties would be jeopardized. So in this case, we have a civil damages case concerning a cartel, a number of companies which had participated in a cartel for many years, between 1994 and 2002. These companies subsequently were restructured, split up, merged, or anyway, dissolved, so that the original addresses of the cartel decision, so the authors of the infringement, no longer existed at the time the victims of the cartel pursued damages in court. So the question, which legal persons and according to which law are liable in an action for damages caused by an antitrust infringement. So the court gives this answer by using the notion of undertaking, the general notion of undertaking, which we have analyzed in this afternoon. So the entities or persons required to compensate are the undertakings as defined for the purposes of a competition law, which participated in that cartel. But in this case, it's relevant another rule, well known by EU law, the economic continuity rule. So, liability for an antitrust infringement may, under certain circumstances, follow the assets of the company involved in the infringement rather than staying with the legal entity which possessed or controlled such assets at the time of the infringement, which is the minimum requirement in order to reach this strong conclusion in legal terms. The minimum requirement for this principle to apply is a pre-existing economic or organizational link between the transferor and the transferee of the undertaking involved in the infringement. In light of these considerations, the conclusion on liability is that in a case where all the shares in the companies which participated in a cartel were acquired by other companies which have dissolved the former companies and at the same time continued their commercial activities, the acquiring companies may be held liable for the damage caused by the cartel in question. So the court confirmed that the same entities, the same notion of undertakings, which have violated the rules of competition law, are at the same time and in the same manner subject to sanctions, for example, by the EU Commission for penalties, for fines, and legally liable for private damage. And the same assessment should apply, of course, for the cases of abuses of dominant position, because these decisions of the court contains a general principle of competition law. The second landmark judgment of the court is Tibor Trans on 29 July 2019. This is a jurisdictional question, but very interesting, because in this case, the national courts had to establish whether which are the criteria to state the competence to hear damage actions for infringements of competition law, but under regulation 1215 Brussels the first. The two principles stressed and elaborated by the court are the following. First of all, victims of illegal cartels can lodge an action for damages against each and any cartel member before the courts of the member state where the market has been affected by the infringement, provided the damage occurred in the respective member state. And this also holds true for actions directed against cartelists with whom the victims had not established contractual relations. In this case, we have a decision by the European Commission concerning several truck manufacturers, the so-called trucks cartel. These trucks cartel, in the form of a single and continuous infringement, consisted of collusive agreements on the coordination of prices throughout the European area for medium and heavy-duty trucks, as well as the timing and the passing on of costs for the introduction of new emission technologies. Tibor Trans is the claimant, the damaged claimant and the undertaking, which claims before the Hungarian courts for the artificially higher prices of the trucks paid to dealers and the finance leasing companies in Hungary as a result of the distortion of the market caused by the trucks cartel, in which DAF Trucks, which is the defendant, in this case one of the members of the cartel, participated. The defendant contested the court's international jurisdiction because they say none of the collusive meetings took place in Hungary. The conduct didn't take place in Hungary, and on the other hand, they say we never entered a direct contractual relationship with this Tibor Trans. So in the first in the first phase of these proceedings, the Hungarian court declined its jurisdiction, and the case arrived at the attention of the Court of Justice, which states these important legal principles. The action for non-contractual damages, because this is a case of non-contractual damages, falls within the scope of civil and commercial matters under the meaning of Brussels the first. In second place, we have, in this case, the joint and several liability of all the undertakings which participated in the cartel. Solely the place of the damage resulting directly from the event giving rise to it can serve as ground for an alternative jurisdiction. But this is the main point. The place where the harmful event occurred covers at the same time the territory of the member state where the market is affected and where the claimant has suffered damage due to distortion of market prices. And in this decision, the court affirmed also the principle that the right of a legal successor of the initial victim must be, can be exercised to claim for damages. So the conclusion of the court is infringement of competition law which concern the European economic area per se automatically entail a distortion of competition in each and all national markets of the member states. Secondly, higher costs imposed and or passed on the purchasers of a cartelized good are immediate consequences of the infringement. We have here the case of direct damage and not an indirect consequence of the damage initially suffered. And thirdly, and the consequence is that the place of the damage suffered by direct as well as indirect purchasers can serve as a basis for the establishment of jurisdiction of the special jurisdiction under Article 7.2 of Brussels. The final landmark judgment by the Court of Justice was delivered on 28 March. The highly complicated question concerned the application ratione temporis of the damages directive, but for me and for our purposes today, it is important to stress the part of the decision which concern the principle of effectiveness for damages sections before national judges. Because in this case, we have a corporation, Progetto, which was a shareholder of the Portuguese company Cabo Visao. Cabo Visao filed a complaint with the Portuguese Competition Authority against Sport TV Portugal. The Competition Authority imposed a fine, so assessed the infringement of competition law with a final decision for abuse, in particular, of its dominant position on the market at issue. And the consequence is, so we have the public enforcement and consequently the private enforcement. Progetto, which is the damaged undertaking, brought an action against Sport TV. The defendants says, but this claim for compensation is time-barred on the basis of the Portuguese Civil Code, because the Portuguese Civil Code provides that the right to compensation expires after a period of 3 years, which runs from the date on which the injured party became aware of his right, even if the injured party didn't know the identity of the person liable. Damages section, in this case, was brought before the expiry of the deadline to transpose the directive. The Court of Justice says short limitation periods that start to run before the injured party is able to ascertain the identity of the infringer may render the exercise of the right to claim compensation practically impossible or excessively difficult. Secondly, the same holds true for short limitation periods that cannot be suspended or interrupted while the authority is making its decision for all the duration of proceedings following which a final decision is made by the national competition authority or by a review court. So the consequence is, thirdly, that the limitation period such as the one in the Portuguese Civil Code is incompatible with the principle of effectiveness. As a consequence, the respective national provision, we know, must not be applied. This topic, and in particular the strengthening of the powers of the decentralized authorities, the national authorities and the national judges, this is a process which continuously grows. So the sources of law and our skills are continuously under examination, because we have a new directive, number 1 of this year, adopted on 11 December 2018, which concern the power of the competition authorities of the member states, which are called to be more effective enforcers and to ensure the proper functioning of the internal market. The objective is to ensure, and this is particularly important, the independence and resources of each national authority in each and every member state, as well as to improve their respective enforcement and fining powers, allowing them to more effectively, I'd say, allowing them to be more similar to the EU Commission. And the second source of law of non-binding, it's an instrument of soft law, but very important for us, for national judges, which in the future I think will be called more and more to settle, to decide damages sections for competition law infringements, is the guidelines of the Commission, of the European Commission, on how to calculate the pass-on of price overcharges. Because we have said that the Antitrust Damages Directive helps citizens and companies to get compensation if they are harmed by infringements of EU antitrust rules. And this applies not only to direct customers of companies having participated in the cartel, but also to indirect customers. We have seen this aspect in one of the landmark judgments commented, and the final consumers, of course. And it is for us, for judges, for national courts, to decide upon the level of such compensation. In such cases, it is a really difficult task. However, determining the amount of overcharges passed on to indirect customers can be particularly difficult. Can be is always, for me, particularly difficult. This is why Article 16 of the Damage Directive foresees that the Commission issues non-binding guidelines to help us, national courts, estimate the share of the overcharge passed on to indirect purchasers. So the Commission issued these guidelines on 9 August 2019 for national courts, and I indicate here the website to find this important document. The other important purpose and challenge for us, I think, in each EU member state, after the directive of 2014, is on the one hand, to become more aware of this topic under the technicalities of the compensation of the damages suffered by the undertakings. So we should be more aware of this challenge on the one hand. But the other thing which I'd like to stress is that national judges should cooperate with the national authorities, the national competition authority. Conversely, the national authorities should aid the judges to develop this calculation, to develop this reasoning on the causal link between the infringement and the damage. But in these so difficult years for the Europe and for the project of the European Union, I think and I hope that all of us national judges can develop fully the skills to settle and to improve this challenge. It's difficult, but our job is interesting because we don't do easy things. This is my thing in this regard. And the final consideration is that, for example, in Italy, in my experience as a judge in commercial matters, we, in the last year, have started to analyze cases from infringements of competition law, and it's a real difficult challenge for the Italian judges. For example, the Italian government has created the Tribunale delle Imprese, tribunal of the companies, because the difficulty of the topic is so great that specialized judges are required to decide this terrific pass-on of price over charges. I read this phrase, and this is only by reading it terrific for me. Thank you.
Sorry, we very hurry. We need to go to the Cappella Sistina, to Museum Vatican. Please, the bus waits us at in 15 minutes in the same place that leave this morning. Remember, we can do all together, of course. Don't worry. Okay, and please, you can give your passport or ID for the microphone. Okay. Thanks. See you later.
Io l'ho vista ma torno a Napoli. Ho cose familiari che mi parlano, se no mi sarei sentito anche, perché anche domani perché ormai sono sempre quelle cose. Comunque sono un bel gruppo. Diciamo il 90% attentissimo. Sì. Grazie, prof.
Sì, un po' d'acqua.
Vabbè, è andata.
No, è andata su, poi è andata molto bene.
No, perché poi quando è un po' pausa sta cosa, però bisogna pure spiegare.
Non è colpa tua. Poi sei solitamente chiaro, quindi sì.
Quello